Mr. P. Sharma, Learned Counsel for the petitioner, on instruction submits that the petitioner desires not to press the matter any further. Accordingly, accordingly, he prays for withdrawal of the writ petition. Said prayer is not objected to by the Learned Counsel for the respondents. So, in view of the above, the writ petition stands dismissed on withdrawal.
Hand your pleasure.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item 17 of today's agenda.
Item number?
17, ma'am. Hello, Senior Counsel, Mr. M.K. Chaudhary is out of station.
How is this matter maintainable now? There is a special court constituted under the Land Grabbing Act?
Not yet, my lord. That's
Not
why-
yet constituted.
My lord, the maintainability was to be decided.
That's what. We are ready. Who is out of station?
Mr. M.K. Chaudhary.
Huh?
Mr. M.K. Chaudhary, Senior Counsel. That's all.
On the prayer made on behalf of Mr. M.K. Chaudhary, Learned Senior Counsel for the petition, appearing for the petitioners, registry to list these matters again on 27/8/2024.
My lord, there is another prayer for item 26 on behalf of Mr. Borkodoki. My lord, he has to go out of town, my lord, so he asked me to cancel it.
On behalf of?
D. Gogoi, my lord. It is sort of Borkodoki.
Saurabh Bhattakur. He's not here.
Not here. He has to go out of town.
See, we had on the last day said that we literally was in your favor to allow the writ petition. No conclusion by the inquiry officer. Nothing. If you don't want to do, okay. On the prayer of Mr. S. Bhattakur, Learned Counsel, appearing for the petitioners, who is stated to be out of station today, a prayer has been made for adjournment of the matter.
My lord,
The matter was fixed today
on
for-
Tuesday,
for hearing, for further hearing. So, in view of the prayer so made on behalf of the counsel for the petitioner, the registry to list these matters again on 28/8/2024. So, this matter would not be treated hereinafter as a parted item.
I would like to-
Yes, Mr. Var, you have come back
Close.
yesterday. Everything is done finally. Then,
Lordship, I beg to mention item number 3. Accommodation for today only, your lordship. Any other date, your lordship?
okay, it's a very touchy matter.
Lord.
But one thing, Mr. Bhattakur, you need not be here. I just want the respondents to bring on record their stand because they have filed affidavits.
Lord.
But the basic issue as to why it was given only to 4
Lord.
and not to the others, that has not been
Lord,
made.
Lord.
So I would like to have that
Lord.
affidavit also on record. So you need not be here. We'll record your name. We'll ask them to file an affidavit
Lord.
of that context.
Deeply obliged.
Otherwise, it will be of no use. It will again go back next day, same thing we'll have to do. On the prayer of Miss So-and-so, not doing, registry, on the prayer made on behalf of Mr. R. Majumdar, on ground of personal inconvenience, the matter is prayed to be adjourned, on behalf of Mr. R. Majumdar, on the ground of personal inconvenience, the matter is being prayed to be so adjourned today. Full stop. The prayer is not objected to by Mr. K. Gogoi, CGC, appearing for the respondents. Full stop. In view of the above position, registry to list those matters after 4 weeks on a date to be fixed by it. Full stop. The matter would not be treated as a parted item anymore. I can't read this brief anymore. Done. Done with.
Of course.
Done with. Mr. Majumdar is not around.
He's on his way to the airport to receive his daughters who are coming from
Okay,
Delhi.
okay.
Then lordship, next.
Try it in a more convenient atmosphere. Yes. Get hold of someone.
My lord.
Time being. Yes.
Yes, lordship. Advocate is supposed to appear in this matter. also.
But one thing, where is that affidavit of the reason why it is limited to 4 districts
Lordship.
and not to the
Other.
other districts? Why that affidavit is not coming on record?
We'll file the affidavit, we'll take instruction. Lordship. One affidavit is already filed. Lordship.
But therein there is no mention.
Not mentioned. Lordship.
So this court had white order dated 29/2/2024 recorded as follows. A to A. Also, today, when the matter is listed, the learned counsel appearing for you are appearing for
For revenue department. Lordship.
revenue for the revenue and disaster management department submits that the instructions in this connection has not been yet received by him, and he prays that he be granted 2 weeks' time to receive the instructions and file the affidavit in the matter.
And for respondent 3 and 4 on behalf of Mr. Aadhar. Certificate receipt.
Also, prayer accepted. Registry to list this matters again on 27/8/2024. So, on the next date of listing, before the next date of listing, the respondent authority shall bring on record the affidavit in terms of the directions passed by this court wide order dated 29/2/2024 and extracted herein above. Also, list this matter again. Miss so-and-so, Miss
A Longcomer.
A. Longpan is present on behalf of the respondents number 3 and 4. 3 and 4. Mr. S. Bothakur, learned counsel for the petitioner, and Miss so-and-so is present for the respondent number 3 and 4.
Obliged.
Obliged. Wait, please, your lordship. Lordship, the matter may be passed over for the time being. Highly obliged.
S. Bothakur. S. Bothakur. S. Bothakur.
Please, your lordship. Lordship, I am appearing on behalf of Mr. Tejas Mahanta. Kindly pass over the matter for the time being, lordship.
Time being.
Much obliged.
Malaj, our little accommodation, Malaj. My senior is on legs in port number 1, Malaj.
Time
Rest
being.
of the sentence. Deeply obliged.
Item 15 and 16.
What happened to Mr. Das today?
Is not there. The finance. Can I start my job?
What if they don't come up again, the same thing? What to do? What to do, Mr. Bushu? Time being?
Timing.
Time being.
My lord, sometime maybe for the time being, the matter may be passed over.
Okay. Time being.
21 to 23.
Today, it seems that nobody is interested to do matters. Your respondent is also not there. If this was told to me in the morning, I would not have come. I would have taken a break. Mr. Gupta, we'll have it at 2 p.m. You get hold of Mr. Singh also.
Twenty-four, 25.
Lordship, matter kindly pass for timing one. Please.
Wait, this I can do something. Hey, writ appeal order today. Writ appeal file today. Mr. Dotto is here. Mr. Monto is not here. Mr. Dotto,
Hello.
Mr. Monto is having some problem. He is on leg somewhere. We'll have it after some time. When it is time, she will come and call you. When they are free, both of you come. You need not wait.
Or, my lord,
Writ appeal order to us, no?
tomorrow, my lord, if your lordship. I think your lordship told for the record.
Hmm. Hey, record to call 6005. Okay. No, no, ठीक है. Yes, copy was received by you.
My lord, I am coming to that.
Hmm.
What happened? It's a very clumsy thing. I did not like to go, but my lord, I must explain it. Now, that copy was given to the clerk. My lord, this case, your lordship kindly see it is engaged case. And the clerk which they have given, my lord, he is not attached in this case. And my clerk never gave me that. My lord, another thing, your lordship kindly see. If I was knowing these facts, my lord, while arguing the case, will I support the APSC? Well, your lordship will find in the paragraph 20, I have supported Mr. Mahanta. Now, if I know that I am out, whether I'm that fool, my lord, I will accept their argument.
Have you also in the present petition prayed for review of this portion of the order?
Yes.
At para 37,
Your lordship is in which matter, my lord, review?
but review matter, my order dated
Yes,
16/5/24. Have you prayed for review of this part? 37.
my lord, yes, I have come up for clarification of this.
But
Lord,
now
no-
see, you are also placed similarly like those two writ petitioners who were held to be not eligible on behalf of their educational qualification. You also in probably that is the reason. Now, I had directed that they wouldn't be eligible to come back and assail that thing
Yes.
once this election process is over.
That your lordship is clarified that whenever any person is aggrieved with the selection process, they can come up. Well, for that, my writ petition is there already. I have my.
No,
review
now, should I also not extend that to you, para 37 to you?
It is already there.
So today, how can what is the reason for his ouster, Mr. Monto?
My lord,
What is the reason for his for he being held to be ineligible?
qualification, my lord.
Qualification.
Qualification. By
That will
the
be co-
expert body, my lord.
That will be covered by para
By the expert
37.
body, my lord.
That, my lord, I will explain whether it is by expert body or FPSC on their own. Affidavit, they have said on FPSC on their own, they have done it. My lord, I will take your lordship to that. Now, the first thing is if your
No,
lordship
that is not the
goes to
challenge, my lord. That is not the, they cannot challenge it now, my lord.
Well, let
He is a
me
respondent, my lord. And my lord, your lordship kindly see if your lordship entertain, my lord, if required, I'll file affidavit, my lord. And my lord, your lordship kindly, what is
No,
their
no,
fear?
that
What
copy.
is their fear? Review the order. What review? Your
No,
lordship
let
kindly
me-
see the,
Let me
Where, my
explain
lord?
slowly, my lord.
no, my lord, why I am submitting, my lord? Your lordship kindly see, my lord, they are allowed to sit in the examination also, my lord. In next, my lord, there is another case filed, my lord. Yes, they are allowed to sit, my lord, in the, but subject to result. That petition is also pending, my lord. So, and in this stage, my lord, suppose, my lord, that I don't know what is the result because the court asked me to keep in the sealed cover. If passed, then only, my lord, everything will be open, my lord. Otherwise, not, my lord.
No, fine. That
But
would,
regarding review, my lord,
Mr. Monto, first we'll have to consider the review.
my lord,
and thereafter we can go into the writ petition. So we'll hear Mr. Dotto on the review first.
My lord,
Thereafter, we'll take the
my
next
lord.
step.
No, if required, my lord, I will file affidavit. I am ready to file affidavit because I have nothing concealed. If required, my lord, that's why I may be given to my chance to my lord file the affidavit, my lord.
If the occasion so arises,
my
we
lord.
will surely give you.
My lord.
My lord, very short question, my lord.
Okay, a review to you.
In the review petition, we have said the ineligibility of 15 candidate was never argued. And to cut short that matter, my lord, it is not required to file anything.
Mr. Dotto, we'll go a step further. We will go whether the 15 you could have been, the rejection of your case is based on any material, or whether that is permissible.
No, how the.
Because if not, I'll have to now also bring you within 37. So you will have to take yourself out of para 37.
No, my lord, my argument would be, what we have said, why we have come up for review. This point was never argued, my lord. If your lordships pleases, let the matter proceeding on 16.5 be reopened. Let all see together whether it was argued.
That was not required to go into because no objection on that lines were taken.
I have heard the matter, my lord, with the proceeding, there is 16.5. I have heard again and again after making myself sure.
This court may have
that
made a
that was
mistake
never
in not,
approved.
this court may have made a mistake in not going
No, no,
between the
no.
lines. But from that side,
Not the
this had
lordship,
not come in.
My specific argument is that it was never argued. Your lordship can reopen the matter on 16.5. Your lordship will find it.
No, I accept that.
I'm not saying just like
There
that.
is no dispute. There is no dispute that that factor was not argued with. But it
All
is
right,
also to be noted,
The next question would be, my lord, 41 ineligible candidates, how it was done by the expert committee. Now the 15 ineligible candidate.
you
whether
take
it
me,
is-
take me directly to that material. That this 15 was done not by the expert committee, but
Yes,
by the
yes, my
APS.
lord, I'll take your lordship to that.
Against clerk will.
My lord, I'll invite your lordship's attention in writ petition number 3505 of 2024.
3505.
Your lordship may see the purported lease dated 28/11/2022,
Page.
page 128. The lordship will find there is no date here. It is not by the expert committee. It is signed by one controller of examination. Now, whether it inspires any confidence.
Okay. This was part of the earlier affidavit.
Yes.
Earlier affidavit, my lord, when they filed it earlier on 2023, we are not the party here. We came later, January 2024. Therefore, my lord, we did not have all this.
Just to.
My lord, your lordship, kindly see a very interesting thing. They filed a writ appeal. Now, writ appeal, my lord, we were along with the APSC. We said that this order should not be interfered. Now, if we are agreed by that order, whether we'll argue that, my lord, in the appellate forum also. And when we file the writ, we got the copy of the writ appeal, we get to know all these affidavits. No, sir.
The writ appeal filed by? Writ appeal filed by?
Filed with the petition in the writ petition.
Earlier, 6005 or you?
60.
They have filed an appeal here.
Writ appeal.
That is pending.
That is pending.
So you are also made a party there.
Yes, we have been a party. And even there we supported the APSC. On that day, my lord, the evening we came to know when the list was came out, we found our name is not there. Only that day we came to know. No, no, otherwise, how can we support APSC while arguing the case before your lordship? And this is the only document, and therefore, my lord, your lordship can see the record whether they have any expert body has scrutinized this. My lord, these 47, my lord, candidates from the mechanical, my lord, they were shortlisted by the expert committee. They found that we are fit, we have all the qualifications.
So it's basically whether the initial shortlisting was proper and the subsequent exclusion of your name
Yes,
was improper. To
exactly.
that extent only.
That's the only thing, my lord. And my lord, if we are our name candidates have been rejected, whether it has come up in the website. It was never. And in terms of the advertisement, they are required to do that along with the regions. Till date, we
Okay,
do
in
not
the
know what is the region.
affidavit that is filed, where is this point read with that affidavit which is in dispute now? Wherein this list was brought on record,
My lord,
page 128,
124.
that is the affidavit,
Page 124.
1 to
4. Maybe para number, your lordship will find para number, my lord. Yes, something number para.
para number page 90. This is a continuation of just above para 9.
Yes, 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 yes. That's above para 9, correct, my lord.
10 page.
124 and 124, yes.
Now, Mr. Monto,
My lord.
who has carried out this verification?
Your lordship kindly see, my lord. May I read this, my lord?
Hmm.
That the deponent beg to state that on receipt of the objection from the petitioner in respect of 2 candidates among the newly qualified 12 candidates, the commission decided to conduct a fresh verification on all the candidates, including the earlier verification. Verification. Yes, yes. 41 and appearing by interview. It is also found that the 2 candidates among the 12 newly qualified candidates were also be found eligible. Your lordship kindly say clearly. For 15 candidates were also ineligible for appearing in the interview. It is also found that the 2 candidates among the 12 newly qualified candidates are also found ineligible. The expert committee, after verifying the educational qualification of all the candidates, again have submitted a fresh list of eligible candidates to the commission on 28/11/2020 on the basis of the expert committee. New list of qualified candidates to be called for interview for prepared by the commission. So that
Okay,
is very
Mr.
clear.
Monto, you
So,
take
and
your-
that is-
Mr. Monto, you take your seat.
My lord.
Now, Mr. Dotto, what is the material to counter this paragraph in your application or review? Because your case is that was done by the APS. We'll have it verified.
my
Don't
lord,
worry.
your lordship can you see the paragraph 8 of their affidavit? They themselves have said.
At page
At
85,
page 90, my lord.
90.
Yes. The
Hmm.
last part, my lord.
Hmm.
That the deponent begs to state that on receipt of objection from the petitioners in respect of 2 candidates among the newly qualified 12 candidates, the commission decided to conduct a fresh verification of all the candidates, including the earlier verified candidates, and found that apart from 41 another, 15 candidates were also ineligible for appearing in the interview. Now, my lord, who has given them?
Just proceed further. It is also found that
the 2 candidates among the 12 newly qualified candidates were also found ineligible.
now the
The expert committee, after verifying the educational qualification of all the candidates, again have submitted a fresh list of eligible candidates to the commission on 28/11/2022. On the basis of the expert committee, the new list of qualified candidates to be called for interview is prepared by the commission. Now, if it was done by the expert committee, let them show from the record.
Yes, my lord, right now I can show. Right now, my lord. If you have a copy one, my lord, I can show him.
My lord, otherwise, the lordship has seen earlier occasion, they took a leave from the court. Now,
Well, on this
all
case.
these exercises were done. in
no,
terms-
fine. If it is again done by the expert committee, same by the expert committee,
No.
And
it
that
was
is
the
also by the
decision
court
of
order, huh?
Expert committee,
That is also by the court.
that they are all eligible. Now again, they're saying that the expert committee again said.
The signature, your
And
lordship
did
kindly
they
see.
inform us?
Bottom, my lord,
What
yeah,
is the reason
signature
for
of the
it?
expert committee, my lord.
You are for Amartya Bharadwaj.
Yes.
Ms. Sharma, show this to Mr.
It is an instruction.
Where are the grounds of the review in the review petition? So, Doctor, there is any grounds given here?
My lord, the record, I'm told, record shows that qualification does not match. The meaning is what? my lord? Till date, we do not know for what reason. It
Mr.
is incumbent upon them to give reason at
That you
least.
have a writ petition pending, therein that thing can be done. Whether your qualification is matching or not matching, we'll not go into para 37. We will ask the, we will consider that in the, what do you call that, writ petition that is there. Because now, yesterday there is a decision of the Supreme Court also,
Yes, my lord, I have seen.
wherein
Regarding
it's
qualification.
following Zahur Ahmed and all, it is now very, it has narrowed down the scope of this court to proceed to declare equivalence. It said you cannot. Equivalence is something which is to be done by the authorities and not by this court.
My lord, another thing, your lordship can see. Now,
Unfortunate, Mr. Doctor, unfortunate, but can't help it.
Now, one thing your lordship kindly appreciate. Now, if they say we were not eligible, now how they are saying that? Now, if you really found that there are certain things when the expert committee has said we are qualified, now again the same expert committee will say that we are not qualified.
Mr.
Is it not
Doctor,
arbitrary, my lord?
Mr. Doctor, let us not go into what has happened. What has happened. But I'm ready to even consider your plea.
My lord, I'm obliged for that.
I'll consider your plea that the finding has arrived at by the expert committee pertaining to your qualification is erroneous. I think that will solve your issue.
My lord, I'm totally, my lord.
That will solve your issue, but that we cannot do in the review. We will have to do for a challenge to be made to that effect
No,
in a writ petition.
Our writ petition
Have you
is
taken
also
that
challenged
plea?
on that also.
Have you taken a plea with regard to your qualification in the writ
Yes,
petition?
yes, everything.
We'll consider that.
We'll file a affidavit because very.
That's true. You file an affidavit there.
But apart from
We
that,
have received, my lord.
apart from that, now supposing you find me, I'm not eligible. Was it not your duty to inform me?
That,
We were
that,
fighting
that, that,
along
that,
thing.
Mr. Doctor, that is why I said, young boy is before us.
Exactly, my lord.
We will give him the maximum possible leave. We will try to examine his case on merits. We will not go into the technicalities. We will go straight to the point whether the conclusion of the expert
Yes.
committee was correct or not. You satisfy us on that. We will not go into any other technicality because a mechanical engineer might have, he is having a lot of hopes. We don't want to depress him. If we want to hold that he is not eligible, it should be on merits.
Yes.
This is the view of this court.
That's fine.
So we will not proceed with the review. And we will concentrate on the writ petition. We are giving you liberty now that the material for which exactly your case was rejected is before this court. You can take note of that and file an additional affidavit in support of that.
I'm very obliged. to you.
Why should we go into all this? He has given you a copy. That small young advocates arguing, maybe looking, but you two stalwarts, that will not be a point before this court.
No, my lord, again I am submitting. What hurt me, my lord? My personal.
Mr. Mohanto, your feelings were considered by this court even before you even opened
My
your
lord.
mouth. Then why should you have a grievance for the?
Not now, my lord, but they are in a written, that's why.
And I know Mr. Doctor for a long time now. If he had that material with him, he would have gone hammer and tongs on me on that day. Unfortunately, that material for some reason was not with him. Or maybe
No.
overlooked, maybe overlooked. But he had that material and did not argue. This court is not going to accept that. Mr. Monto, both of you have your own grievances.
My lord.
Let us give it a closure. Let there be no further anything bad here.
No, if
We will
anything wrong
argue
from
the
my side,
matters
I will
on
learn-
merit.
I will learn, my lord.
We'll
But my lord-
argue the matters on merit. The copy Mr. Doctor has projected was received by an advocate clerk.
Is it my fault?
No,
Then
be that as it may.
his clerk, my lord.
These
yes or no,
are
submit to him.
fate. These are things
No,
which
my
were, Mr. Doctor, these were Mr. Monto, these were things which were ordained to happen, have happened, let it happen. It's gone. We'll not go back and open that chapter.
But when it is, my lord, on record, then, my lord, it hurt me. That's why I'm submitting, my lord.
You forget it. That is why I'm going to close this.
My
And
lord.
So that
I-
no
I
further.
Clarified, my lord, what had happened. It is an engaged case. My lord, they have
Oh.
given the copy to somebody
Oh,
else.
Mr. Review petition, RP number 128/2024. Heard Mr. S. Dr. Leonard Senior Counsel, assisted by Mr. DJ Medi. Also heard Mr. T. PJ Monto, Learned Senior Counsel, assisted by Ms. P. Sharma, Learned Counsel, appearing on behalf of the APSC authorities. The present review petition has been so instituted on various grounds, assailing, praying for review of the directions passed by this court wide, praying for a review of the order dated 16/5/2024, passed by this court in WPC number 6005/2021. Also, the basic grievance of the, amongst others, one of the grievances raised by the review petitioner in the present proceedings is to the effect that the factum of his name being his candidature being held to be ineligible in the selection process after the expert committee had in the initial stage of verification found him to be eligible to participate in the selection process, comma, and he having been allowed to participate in the selection process, comma, and this aspect not being argued by the respondent authorities in the matter while the hearing in WPC number 6005/2021 was so undertaken, comma, has led the petitioner to institute the present proceedings. Also, Mr. Doctor submits that the said aspect that the petitioner was subsequently declared ineligible by the APSC authorities on account of APSC authorities what was not to his knowledge, and accordingly arguments in this connection could not be placed on record. Also, per contra, Mr. Mohanto, Learned Counsel for the petitioner, submits that the materials brought on record by the APSC authorities in the proceedings of writ petition number 6005/2021 amply demonstrated the fact that the petitioner's name was excluded from the select list, from the final select list as published after thorough verification of the educational qualification and other eligibility criteria possessed by the candidates participating in the selection process. Full stop. Be that as it may, today when the matter was taken up, the contention of Mr. Dotto, learned senior counsel, was that the exclusion of the petitioner herein from the purview of the said selection process was not so made by the expert committee, but was made by the APSC on its own notion on a verification of his qualification. However, Mr. Mohanto, by producing before this court the minutes of the verification process undertaken by the expert committee, contends that the exclusion of the petitioner the candidature of the review petitioner from the selection process was not made per se by the APSC, but was so made on the recommendation of the expert committee constituted in the matter. First off, in view of the above position and it now having come to notice that the petitioner's name was so, the candidature of the petitioner was so excluded from the selection, from the purview of the selection process on account of the qualification as possessed by him, the said aspect of the matter would now require to be adjudicated by this court. Also, in view of the above position and as agreed to by the learned counsel for the parties, further adjudication of this review petition is not called for, and accordingly, the review petition stands closed. However, it is to be observed that the candidate exclusion of the rejection of the candidature of the petitioner herein would be so adjudicated in WPC number
3505.
3505/2024 as filed by the petitioner, review petitioner herein and presently pending disposal before this court. Also, in view of the above observation, the review petition stands closed. Okay.
Can your lordship fix a short date?
Mr. Monta,
My
how
lord.
long will you take?
Let me be 2 weeks, my lord.
To it. Hard, Mr. Eke Kotha, hard arrival review petition or Mr. Mohanto has produced before this court the verification as the records of the verification process in respect of the petitioner's qualification as carried out by the expert committee, and a copy thereof has been furnished by Ms. P. Sharma, learned counsel appearing for the APSC, to Mr. DJ Medi, learned counsel representing the petitioner herein. Also, in view of the above position, while permitting the APSC authorities to file their affidavit in the matter, liberty is also reserved to the petitioner herein to bring on record file an additional affidavit to bring on record his contentions with regard to the conclusions now reached in his case pertaining to the qualification process by him by the expert committee. So, how long will you take?
2 weeks. my lord.
Register to list this matter again on, will 28th be fine?
Not 28, my lord. Hold on. 30th.
30th.
Feasible.
Also, list this matter register to list this matter again on 30/8/2024.
Well.
It is required that the parties would bring on record their respective pleadings as may be called for on or before the next date of listing. An endeavor would be made to subject to the completion of the pleadings by the parties in the matter, an endeavor would be made to consider
With your lordship,
if it doesn't come back to me, it
My lord.
doesn't look good.
with your lordship's kind indulgence, can I make a short prayer? my lord, the record which my lord has shown. Can he part with a copy of it?
Hmm?
Just a copy of the same, photocopy of the same.
The photocopy I have said, photocopy will be given to you. That inquiry.
That actually, my lord, everything will be, my lord, on affidavit, my lord. What about a record, my lord? I'll place the original record also, my lord. That is the funny, that is the record furnished to us, my lord, by the PSC.
Okay.
And the head that I am hearing, my lord, I am
DJ amount of
recording.
diabula line to us. Let him file you file an affidavit then before that.
My lord,
It last of all DJ amount of disable DJ medic dia, it continue. The APSC authorities shall file their affidavit in the matter on or before. When? When will you file your affidavit?
before 30th, my lord. I will-
No, but I'll have to give him some time
My lord.
to file an additional affidavit and a reply there.
Because, my lord, there are two another matter also there, my lord. We have to, my lord, actually.
So 21st will be possible.
And before 25th, my lord.
Huh?
Before, sorry. 22nd, my lord.
22nd. But before 22/8/2024.
Will be done.
For some, the petitioner thereafter shall file is a reply as well as an additional affidavit to bring on record further contentions pertaining to the decision of the expert committee
Expert.
relating to his educational qualification on or before 28
29.
or 29, when it be convenient.
28.
28. 28/8/2024. List this, register to list this matter again on 30/8/2021. So everything resolved now.
Yes.
Everything resolved now.
Obliged.
Caveat, there is a caveat. The writ petition doesn't. List check. List check. We'll finish up the list, mister. We'll just finish up my list. Exactly, 27, 28. 27, 20. Oh, hit a hearing needs. Okay. Yes.
Yesterday matter. It is yesterday matter also regarding the
Yesterday's matter.
hearing matter.
So what should we do? We'll have to close it in terms of that division bench judgment. Who is there? Opposite party?
Some excess revenue I have deposited.
We can't because the court has said that PPP was ab initio void. Also heard Mr. ABT Hupp, Learned Counsel for the petitioner. Also heard Mr. P. Sharma, Learned Counsel appearing, or Mr. S.K. Talra. Who was there yesterday?
P. Sharma.
P. Sharma, Learned Counsel appearing for the AFDC authorities. Also, the petitioner in the present proceedings has presented the challenge in the present proceeding is to a communication dated 21/2/2020 by which the managing director Assam Fishery Development Corporation had cancelled the extension as granted to the lease of the petitioner herein. Wide order dated 22/2020. Also, the facts requisite for consideration of the issue arising in the present proceeding is noticed herein under. Also, the petitioner herein was settled with a fishery named Gopasang Group Fishery Meen Mahal, Karimganj, for a period of 7 years with effect from 1/4/2012 to 31/3/2019. Also, the petitioner contends that he had remitted to the authorities the due kist money involved. However, on account of encroachments being made with in the on their set on encroachments being made on a major part of the said fishery, the petitioner could not carry out the fishing activities therein in terms of the projections as made, while the settlement was made at the time of the settlement of the same with him. Also, the petitioner thereafter approached the authorities for remission of the kissed amount and or for granting him an extension of the term of the fishery so as to recoup the loss so sustained by him. Subpara. On consideration of the prayer of the petitioner hearing, the managing director, Assam Fishery Development Corporation, via his communication dated 20/2/2020, proceeded to accept the prayer of the petitioner and extended the lease. Of the petitioner for a period of 3 years up till 31/3/2023. Also, in the manner as specified therein. However, on the next very date, that is on 21/2/2020, they said extension as granted to the lease of the petitioner came to be withdrawn, also leading to the institution of the present proceedings. Also, at the outset, it is to be noted that the lease of the petitioner herein had come to an end on 31/3/2019, and the effect and the order and the communication dated 20/2/2020 extending his lease has the effect of extending a lease after the same had come to an end and not during the currency of the same. It is a settled position of law that a lease public settlement that has the period tenure of which has already expired, the same cannot be extended by the authorities in any manner. Also, be that as it may, it is stated in the bar that the settlement of the fishery in question with the petitioner was in the public-private mode, PPP mode, public-private partnership mode, bracketed PPP, and the similar settlements as made in this connection was assailed before this court in a number of writ petitions, which on being dismissed led to institution of writ appeals before this court. Also, this court in the case in writ appeal number 366 of 2022 and other analogous matters wide judgment and order dated 6/5/2024 proceeded to consider the issue involved and on noticing the and upon hearing the parties to the proceeding therein, by applying the decision of the full bench of this court in the case of Haria Dablong Min Mahal Samabai Samiti Limited, reported in AIR 2001 GAU 139, proceeded to hold that the AFDC authorities had no power of direct settlement of fisheries, and therefore the fisheries as settled in favor of the appellants therein, without calling for the tenders was illegal. Also, applying the decision of this court in the case in right appeal number 366, Nisar Ahmed versus Assam Assam Fisheries Development Corporation Limited, bracket, this applying the decision of the division bench of this court in the case of Nisar Ahmed Supra, it is found that in the present case also the initial settlement as made with the petitioner by the FDC authorities was by way of direct settlement and not by way of tenders, and accordingly the said settlement being void ab initio, any grievance of the petitioner in relation to the said settlement so made would not be, cannot be considered by this court in the present proceedings. Full stop. In view of the above position, the settlement as made in favor of the petitioner being void ab initio, this court is of the considered view that the grievance as raised by the petitioner in the present proceedings for an extension of the term of lease as granted to him in the matter cannot be entertained, and accordingly the writ petition is held to be devoid of merit and the same stands dismissed. However, there would be no order as to cause. Yeah, Peter, as order.
Hearing item 27.
Yes, Mr. What is anything left here?
I don't think anything. If they have anything to settle, it is the floor.
No. The floor
The
test
floor is
was
wide
done.
open for them.
Floor test was done. You conceded to that. Yeah, that floor test went ahead. Now, if anything is to be done, do it democratically. You had one plea that it was not gazetted. Mr. Dubey, unfortunately, is not here, he's in bereavement. That aspect was also clarified.
My lord, our case, my lord,
Other than
My
something,
my lord, something is still alive, my lord, in the petition, my lord. To be, my
tell
lord,
me, what is alive? Mr. Sregya, relax.
Lord, alive in my limited understanding, my lord, is that, my lord, the BTC rules, the election rule, which is required, the very foundation of the council is made by dehorse the rules, my lord. Now, once my lordship arrived at a conclusion, my lord, after hearing, my lord, that yes, there is discrepancies or the rule has not been followed, then what will be the fate of the council, my lord? That council will go. That is the issue, my lord. Regarding
The
the,
only
My-
ground that ground you had raised in this connection was that it was not gazetted.
no, that is one ground, my lord. That is a one ground.
What is the
that
other ground?
Notification was not there and even
That has been clarified now.
that has been clarified, my lord. Even there are discrepancies in that
Well,
clarification.
not
also.
going to that. This is a democratically elected
No,
body.
democratically elected, that is correct, my lord. But the rule of law, which is required to be followed, the governor cannot hijack the rule of the law, my lord. It is a clear case wherein the governor has hijacked and by forceful or in an arbitrary manner, this council had been constituted, my lord. My lord, actually today I am, my lord, a little bit of handicap because one of my colleague who is holding materials, my lord, is stuck in logging, my lord.
Logging still,
Still, my lord, in my area, my lord, boats are flying, my lord. So I have somehow managed to come to the court, my lord.
you.
It is a very, even reliefs are being distributed, my lord. So, my lord, may I pray, my lord, that the immediately after this 15th August, my lord, any convenient day as per my respected Advocate General's convenience.
Advocate General is convenient every day, but thing is whether we should, if there is anything live
No,
issue,
my lord, my
we
lord,
would have.
My lord, the
I
preliminary- yes,
tried to go through yesterday the maximum I could.
My lord.
But I only thing that I found was that gazette notification that subsequently I found that it was also
There
done.
are other issues are also there. If my lordship allows.
Yes, Mr.
My
Saikia.
lord.
In that case, lordship, let the matter be fixed for the other aspects regarding it is an etc.
Huh?
If they are harping on those points, if
Your affidavit is there.
our affidavit is there, and there are some other councils also who are appearing representing those.
Okay, on the prayer of Mr. Heard Mr. A.R. Boya, learned counsel for the petitioner. Also heard Mr. D. Saikia, learned Advocate General appearing for the
Last week of September.
state respondents. Along assisted by Mr. S. Bora appearing for the state respondents. First up, as prayed for by Mr. A.R. Bhuya, raised to list this matters again. When? Give me a date.
last week of September, Lordship.
On 27 is
Yes,
a
Lord.
Tuesday.
Uh,
On 27/8/2024.
27th, 26th will be Thursday, Lordship.
No.
26th.
26th is Monday. It's holiday.
September, my lord.
No. When do you want it? September.
September,
Oh, September. Give me a date.
26th of September.
On 26/9/2024.
Highly obliged, Lordship.
You formulate your, Mr. Mia, you formulate your
Yes.
arguments,
I'll
points,
formulate.
and you give us, then we will see.
My lord, even will submit a small note also.
No need, you give me the points first. Note
Fine.
will come after the hearing.
In all the courts where this matter is listed, whatever has fallen from Lordship's mouth, it was the same opinion of all the individual courts. Go and fight it in the floor of the house.
And I have gone through that judgment
And
of
hardly-
Chavan also.
Hardly 1 year and few months
No,
ago.
I've gone.
Lord, my lord.
I think you should be now gearing yourself up for the next round of.
Election.
My lord, the amount of, can understand, my lord, from the clients also, my lord. They have an expectation.
And most of
It's-
them have switched sides also.
Mr. Soikia, that you are here, I found
Sure.
one matter. A very touchy issue. I think you should also just see. It is item number 4. It's with regard to grant of special protection to Kus Rajbangshi community. Under that chapter 10.
Lordship.
Now, what has happened is government has taken a call and has extended such protection to 4 districts. In 4 districts.
Lordship.
But their case is, if we are required to be granted that protection for 4 districts,
Certain developments are going on. In fact,
Ah.
I am in touch with them.
Ah.
That protection,
Ah.
50%, etc. Lordship,
Okay.
some developments are going on.
if
with
you are
them.
not here
Also,
also, when
there
we
will be some amendments.
no, I have fixed the matter on a particular date. If you are not there also, whoever is appearing
No,
for the
Lordship,
government,
because
you be there.
there is a process for amending the
Thing,
whole-
chapter 10.
Lordship.
Oh, very good.
Highly obliged.
Okay.
I'll look into it. Obliged.
Hey, Jackie, Baki, list to
28.
May please, your lordship.
Hmm.
But in the CPDs of the petition has seven the order of the Assam Board of Revenue as well as the. order
Now,
of-
that my judgment of my Lord Justice Amitabh Roy,
Yes, my lord. I-
was it taken up for appeal? Was it taken on appeal? So in that, you are having a kacha pata.
My lord,
You are having a kacha pata? No,
no annual patra, my lord.
annual pata.
My lord.
Now, whether that would, yes, Mr. Das,
I'm
what
happy
is
for-
your,
I'm happy for the respondent number 7, my lord.
ah,
By way of purchase, my lord,
ah,
I am possessing the land, my lord, 1 bigha, 10 lusas.
hmm,
And now, my lord, my name was, I applied for mutation of the land
hmm,
and they granted the
Hmm.
same, my lord.
hmm,
Against that, they have filed appeal.
hmm,
The legal heirs of original land, my lord.
hmm.
This is the position, my lord. I have plot of land. Now land is in government land. my lord.
Now the land is government land.
My lord, here, my lord, please that they have purchased the land from the, my lord, my father, my lord. But till today, my lord, all the proceedings before the, my lord, deputy commissioner, before the Assam Board of Revenue, no any deeds of, my lord, transfers, they have produced, my lord.
You are not in possession. You are not in,
I am in position.
he is also in possession.
No.
You are not in possession, Mr. Das.
I am in possession, my lord,
Then-
on record.
Still, my lord, the
On record.
What is
proceedings
available?
is continuing.
So why break your heads here? Break your head in the appropriate forum.
No, my lord, because the,
We'll say that the observations as there in the,
but in view of the decisions of this honorable court, my lord, as lordship has pointed out, my lord. The, my lord, order of the, my lord, Assam Board of Revenue, as well as the, my lord, previous orders of the circle officer.
concurrent findings.
But, my lord, that the finding is wrong, my lord. It is in settled positions of law, my lord. In view of the decisions of this, my lord, honorable court pays para 34, 35 and 37, it's clear case, my lord.
Hmm.
I have a
34.
heritable right, my lord, over the annual patta land, unless and until that was, my lord, cancelled. or my lord, non-renewal notice has been issued to me.
Herein, there is a finding somewhere that the annual patta rights will continue to
Yes, my lord.
exist.
Yes, my lord. That's finding of the, my lord, in,
The right of an annual pattada holder during currency of the subsist in him, it has to be construed to be an existing right in such person at the time of his device. And though such right may be one contingent on cancellation of the annual patta and is subject to paramount title of the government in the land, the same would devolve on his heirs, successors in interest by operation of law. The right may be limited, but it exists to be inherited by the heirs and successors in interest of the original annual pattada.
they might not file a suit if they are in my lord possessions or if they have right. But that present order, my lord, it's
Okay, take me through that. Mr. Das, have your say. Take me first through that order of the district authorities, settlement officer.
yes, my lord.
Hmm.
That lordship will find first order of the
Additional revenue commissioner. Yes, page
It-
59.
is five one is the order of the 19/3/18 passed by the additional deputy commissioner.
Hmm. There is another order dated 7/9.
7/9 is page 59.
Uh,
And the order of the revenue board is
page
6/10.
63.
63. 51, 59 and 63.
50?
51, 59 and 63.
Okay. Who is Ashraf Ali
The restaurant number 7.
and Ayub Ali?
My lord.
Ayub Ali
It's a Gaon Brahman.
and others. Okay. Where is the so-and-so, so-and-so, so-and-so land measuring it? 1 bigger so-and-so covered by dark number so-and-so and AP annual patta number 7. Warsaw government in the name of so-and-so. In the peaceful position plus party, no due violation, the patta is cancelled. Send back. So it was given, it was reverted as government khas sarkari land.
My lord.
Annual patta cancelled.
Cancel.
And
Against
when did
that
you
one.
buy this plot, Mr. Das?
My lord.
When was this plot bought by you?
That
2003.
lordship will find is 35. This is the application filed by my lord, respondent number 7, before the my lord Sarkovli officer for mutation of his name. Page 35, last portion, my lord.
This is the same land. Okay. Now, because of this, it was cancelled at page 51.
My lord.
Okay. Then what happened?
Then my lord, I have approached before the my lord,
Deputy Commissioner.
deputy commissioner,
Hmm.
that appeal has been dismissed, page 59. And my lord, the page 59 order, my lord, the additional deputy commissioners go ahead and declare the title of the my lord private respondent number 7.
59.
Yes,
Okay, read. This 59 is in pursuance to page 53, appeal.
51 order against that order.
53 appeal, 51 order, 53 appeal, 59.
My,
Okay. Now, this cancellation and reversion to Sarkari Mati status, that was not interfered with.
My lord, Board of Revenue, my lord,
No, the additional deputy commissioner.
not interfered.
So that land remained a government land,
Sarkari land.
but under the possession of, by, as per till page 60,
My lord,
under the possession of
respondent
the
number 7.
respondent number 7. Title cannot be there, that is erroneous.
Yes.
Because title cannot be decided by.
My lord.
Now you went up before the Board of Revenue.
My lord.
Okay.
Page 60.
Page 63, my lord.
Hmm. Manjum Ali is your father.
My lord.
The total parcel of land is 3 biga,
No, my lord. They are claiming, my lord.
1 biga. That the total land under your
Total
father's
land, my lord,
possession was 3
1 kata,
biga.
2 lesa.
1 biga, 3 biga, 1 katha, 2 lesa.
My lord,
Annual patta was given for this.
3 biga, 2 kotha, 1 lesa. 2
3
ducks are
kotha.
there.
No, 2 ducks.
Yes,
3 biga, 1 kotha, 2 lesa.
my lord.
And he purportedly had bought
1 bigger.
1 biga,
10
10 lesa.
My lord.
Okay.
In duck number 397.
In of annual patta 7.
Right.
And this 64 is not there.
No.
Not there. 64 continues to be under
Yes,
your
yes.
possession. Okay, Mr. Das.
Hmm.
You went up saying that one katha, 10 lesa land, you have a possessory right
And we
and
got
you
10
had
lesa.
brought it. So that would mean the balance land of around 2 kathas, 2 bighas odd remains with the petitioner.
Right.
Now you file an application for mutation. The settlement officer or the circle officer rejects that, saying that there is no right. Maybe the thought process was there is no right of transfer. Annual patta cannot be transferred. So that application came to be rejected. But while rejecting that, it rejected the whole of the annual patta number 7.
Sir.
So 2 dogs which were involved, there was a dog number 64 also, wherein admittedly, even if you had brought that 1 bigha, 2 bigha remained with him.
Yes.
He goes up on appeal before the additional deputy commissioner. Additional deputy commissioner goes a step forward, saying with regard to, he does not distinguish that the whole thing has been reverted as government land.
Government.
He does not interfere with that, but he proceeds to hold that you have title and possession over the whole land. So that practically was erroneous. Now we come to the order of the Board of Revenue. Board of Revenue order is perfectly correct because in paragraph 8, page 64.
My lord.
However, the order of so-and-so in right dismissal of the appeal of the appellant as the land has already been made khas land. It is erroneous in favoring the respondent by observing that the respondents are peacefully possessing the land with title, which is not the case, as the status of the land in question on that date is government khas land, and therefore attribution of title by the ADC revenue is premature. In view of the aforesaid facts, this board finds no infirmity, so and so, finds the order dated so and erroneous, and therefore sets aside the order with immediate effect. So that order gone. You have not preferred any writ petition against this. Mr. Sharma's, he is to suicide. Now, after this, you have also suicide. The annual patta is cancelled. He has not challenged. Page 53 is the appeal. So, the reversion to government land, neither of you have challenged. So what would be it? You are just possessing a government land now.
Yes. It is.
You have also not challenged
Which order, my lord?
that order of the settlement authority.
My lord, I have challenged.
No, you have not challenged
Yes,
it to you have only challenged to the extent that you want the 1 bighah back. You have not challenged it to the extent of reversion to cancellation of the annual patta and reversion of the land as a
No,
government.
my-
Yes, you come to your prayer at page 57.
50.
7.
57.
Because that order had a further angle of cancellation of your annual patta and reversion of the land as government land.
Now lordship will find the original order of the circle officer.
Page 51.
Is my lord 49. Page 49, my lord. This is the order passed by the circle officer, my lord. 8/3/2018. Here, my lord, the whole my lord patta is not cancelled, my lord. The Exona patta land measuring 1 bighah 10 less are covered by doc number 397 of Exona patta number 7 of Bortozama.
Therefore, the transfer land be declared so and so. Settlement so and so. Therefore, the Exona patta land measuring 1 bighah so and so be cancelled and declared and forward. Now you come to page 51.
This is the original order of the my lord passed by the circle officer.
Huh.
That the my lord hold the subsequent proceeding as my lord,
No, this order 8/3/2018
my lord. That
is
is-
followed by 19/3/2018 of the same
My
very
lord, yes.
authority.
Yes, that
Herein,
that my lord order passed by my lord because in the order itself, it has been stated in the 8/3/2018 that forwarded the relevant documents of the case before the deputy commissioner for approval. And that 19/3/18 order passed by the my lord additional deputy commissioner approving the order of the my lord circle officer dated 8/3/18.
now here there is a order, hence due to violation of so and so, status of the patta is cancelled and reverted. So AP patta number 7 got cancelled here.
My lord, that actually my lord, that
Actually or not
No, no,
actually?
no, my lord, my lord submission is that my lord, that 19/3/18 order is approval of the earlier order passed by the circle officer.
Be that as it may, that has an effect. That has got something on record. Your rights have been violated by this. Or this is of no consequence.
The remaining part of the bill.
The second paragraph of 19/3, page 51 is of no consequence.
My lord, in fact,
Because if it is of no consequence, then why is the order of the para 8, page 50, page. Okay, that is of no consequence. Then we'll have to see the order.
because my lord, in the page 60 order also,
Hmm.
the my lord, additional duplication is my lord confined with the my lord 1 bigha 10 kotha, 1 bigha 0 kotha 10 lesser land, only my lord, drug number
Okay,
397.
now you come to page 60, the appellate order.
60, my lord.
Hmm.
Yes, my lord. In
The
my lord,
third paragraph.
hence, my lord.
Hence, the case
Yes.
is
Hence,
dismissed.
the case is dismissed. Appellant's grounds claim over the disputed land as lawful owner is dismissed as per provision of LRR 96. Further, the respondent Mohammed Asraful Ali's names in
The fact that he has
record of
so- so-
entry
so-
with
so-
relevant revenue records reports the fact that he has possessed the disputed land through lawful procedures and possesses as per provision of LRR 1886 for land measuring 1 bigha 0 kotha 10 lesa in DAG number 397 AP number so and so, where the appellant's right are not has found to be curtailed or disturbed by the respondent. Although the status and in questions has earlier in AP number 398, yet it was duly under possession of respondent which got converted to provisions of
So and so duly initiated by the
circle officer.
so and so. Now read that along with the order at the finding of the revenue board
Yes.
at para 8.
That order has already cancelled, my lord. That order has already cancelled.
Which one?
The order of 1918.
Where? Who cancelled?
My lord, the Board of Revenue, my lord,
Where? Show me.
is para 8, my lord.
Read.
Yeah,
It has
however,
been upheld.
No, no,
However, as per
no.
so and so is right in dismissal of the appeal of the so and so, land has already been made.
It is
Khas land.
erroneous,
And Mr. Sharma,
my lord.
appellant herein is you.
Yes, I have appealed.
It is erroneous in favoring the respondent by observing are in peaceful possession of title, which is not the case, as status of the land in question on the date. On that date is government khas land.
Therefore,
Attribution of title by ADC revenue is premature.
In view of
In
the
view-
aforesaid facts, this board finds no infirmity in the order of the circle officer dated so and so and order of the additional.
Dated 19-3.
And next paragraph, my lord. However, this board finds that the order dated 7/9/19.
We are not concerned, but the order dated 19-3-2018
Yes,
is upheld.
yes, that is presently, my lord, in this repetition, I have challenged that order also. And the order of my lord, the 7/9/19, that lordship will be on page 59 order 60, wherein the additional definitions are declared the title of the respondent.
That is gone. That
That
is
has been interpreted by
not.
the, my lord.
But
revenue.
19-3-2018, the
That is challenged, my
cancellation
lord.
of the patta.
In this present repetition, I have challenged that order also.
Now, if we have to now interfere,
My lord, if I will not get any relief before the civil court also, because in the civil court, in the event of holding the field of this present, my lord, Board of Revenues order, I will not get any.
no,
relief.
we will provide for that, because now see, the 19-3-2008, where is your prayers in the present petition?
Yes. Page starts at 18. Original order of the Board of Revenue.
So 3 bighas, 2 bighas is under your possession, 1 bigha is under his possession, right? Can we conclude that 2 bighas is in your possession, 1 bigha is in his possession? Right? So if that be so, the patta is neither, annual patta is neither extended in your favor nor in his favor.
My lord, it has not been cancelled, my lord. Unless it is cancelled, my lord,
They have cancelled it,
Cancelled,
19-3.
already
but
cancelled.
that was order is under challenge, my lord.
Now tell me, can a person under an annual patta transfer that property?
My lord.
Can he transfer?
Yes.
He can. Yes, Mr. Das, what is your submission? That much, that is your case?
My lord, my lord.
But you accept that the claim made by the respondent number 7 to the extent of 1 bigha something,
Without any documents.
be that as it may, he is in possession of that extent, to that extent,
Yep.
right?
As per rules, my lord, but my lord.
Now,
as
if
per-
we interfere with these two orders, still there is no extension. As on date,
If,
it's
my lord,
gone.
if your lordships interfered with the order.
Can we do that?
Yes, my lord, then the original status will, my lord, prevail. If they have any title or, my lord, if they have any right, my lord, over the land, they can file a civil suit, my lord. If they have any,
But if you agree that they are in one bigha, 1 katha
if
possession,
they are in possessions, my lord, they can file a civil suit, my lord.
for what? Only to the extent of the possession, only
No, my
they.
lord, if they have any documents, because they in their applications, they have.
There,
claimed
that civil suit, it being only an annual patta, they can't get
independent
settlement
civil
holder.
suit, my lord, can file.
They can't have a title over that land.
No,
That only the possession.
no, my lord.
Possession you are
No,
admitting.
No, my lord. Only on based on the, my lord, transferable documents, my lord. They are claiming that they have. I
No,
have
no,
transferred
you accept the fact that to the extent of 1 bigha,
my lord.
10 losa, they are in possession.
No, possessions is different part, my lord.
So if that possession is not in terms of law, it is you who have to challenge that.
Yes.
It is annual
Yes, I
patta land.
can challenge, my lord, but in the event of, my lord, holding the present impugn order, my lord.
We can
Then,
record
my lord,
one
civil-
finding. We can
civil-
record your statement that to the extent of 1 bigha 10 losa, he is in possession, which you dispute. Both of you agree that these 3 orders should go. However, with regard to the possession, we require you to take further steps as mandated under law.
If lordship interfered this present impugn order.
I'll not interfere it. I'll interfere it with the stipulation that 1 bigha 10 losa land is in his possession. Think over it. Think over it. We'll have it on Monday. But I'll not make just a, what do you call that, straight away interference, because neither you have title, neither he has title. It's only the possession. We will restore the annual patta. Right? Thereafter, what flows, flows. But we will record, because moment we restore you the annual patta, the whole land is inheritable by you.
Yeah.
So he'll be ousted. So for ousting him, you take whatever procedure you. We'll maintain that. Monday. Mr. Das, anything more?
Oh, my lord. But so far transpires is concerned, it is not
Give me-
forbidden.
Huh? Not forbidden.
Not forbidden.
Ex sonia mati. Finding it very
There is
interesting.
another legal, another legal is there. They are not
Whoever it is.
the party in this case.
So because if I declare the annual patta in his favor, you are out.
Yes.
You are out. So he admits that you are in possession of 1 kotha 10 losa. Continue subject to proceedings under law that will be
Yes,
permissible to do. He'll do it. Think over it.
My lord.
Come back on Monday.
My-
But Mr. R. Sharma, learned counsel appearing for the petitioners, and also Mr. A. Das, learned counsel appearing for the respondent number
7.
7. 8. Who is for 8?
Gangura.
Is Gangura. 8. Also, as agreed to by the learned counsel for the parties, list this matter again on Monday for further hearing.
Pardon.
Further hearing. Further hearing. Monday only. Eto thoi dibo Monday apni dibo. Kintu
Alright.
khali muk kali file kita dibo. Think over it whether that is Mr. Das also, whether this order is legally permissible to be passed by this court. Kindly address me on that also. He is having a very wry smile. What happened?
Twenty-nine.
Also, this matter pertains to an order which has been passed by the ombudsman, rehearse the rules against the insurance
Ombudsman
Company.
rules, which your lordship will.
Yes, madam, you are appearing for?
My lord, respondent number 2.
Okay.
My
Ready?
My senior citizen likes my lord.
Who?
Shishir Dutta, sir.
So they have also, by filing their reply, they have admitted that yes, it was passed against her. They also support my case. Their affidavit lordship will find page 13,
Affidavit filed by?
filed by respondent number 2, that is the chairman, IRDAI.
Oh,
Small point lordship that could the ombudsman have passed an order on a complaint by the consumer?
consumer is not before us.
No, the insurance company. Notice was sent, lordship, if your lordship sees the second file, notice was sent,
Respond
Then-
number 5,
yes, the private notice was sent to them. And
but they have not appeared.
yes, and they have by a letter written to the registry saying that he has some transferable job. So in that case, he cannot appear, and he says that he has received his notice, but he cannot appear. That he
So we will do one thing, we will appoint an amicus here from the legal aid council. We'll give him a legal aid council.
can be,
Hmm?
that will be better.
We have a list of sending more legal aid council.
One point, if your lordship takes up, just one page I'd like to
Hmm.
point out.
Hmm.
This lordship will kindly take up page 98,
90.
Annex 17. Just for a moment.
No, it's a criminal. I mean, who's a criminal? This list wherein your name also figures is for criminal proceedings.
Yes.
Huh?
Same list. I think the legal aid council names are all same for civil and criminal.
Both for civil and civil.
No separate list is made up.
No, this is amicus curiae, like even criminal ne civil. Duta karne legi.
One thing is that.
Where page 98.
Yes, your lordship. Relevant page will be 99. 98 it starts. This is your lordship will kindly mark. This is the insurance ombudsman rules 2016. Below your lordship, middle part. It's a notification dated 25th April 17. Lordship will turn the next page. It's 99. Down below, lordship will see. It's very pertinent. Lordship will kindly mark it. 14, rule 14. Manner in which complaint to be made. That is where I am hitting upon.
Okay,
Then,
we'll have it in the presence of Mr. Dr.
Please, sir.
He's also an expert in this line.
Yes, sir. That is the only point. Prior to that, he ought to have filed a representation before the authority, which he have not done. And he have directly gone to the ombudsman.
You are for the insurance company.
Yes. The order is approved.
There is an interim order.
Yes, sir.
Also heard Mr. K. Monto, Lanark Council for the petitioner. Also heard Miss
S. Musari.
S. Musahari, Lanark Council appearing for the respond number
2.
2. None has entered appearance for the respondent number.
Also, it will be.
Respondent number 3 also none has appeared.
Yes.
3,
4 and 5.
4 and 5. Also. Where is that letter from the respondent number?
Of 5, lordship.
Uh-huh.
That is
Shankar Nade.
record in part second file of your lordship. Part B file.
The respondent number 5. that is the consumer, has informed the registry of this court via a communication dated 22/3/2021 that
is the
But here it is, you have again said has claimed,
the order, my
should be as claimed.
one of the interim order.
That interim order, it was admitted amount.
Admitted.
You filed an affidavit.
My
You filed an IA and it was changed as claimed.
Oh, my lord, that 131 is not the claimed amount. 131 is the admitted amount. That claimed amount is higher.
Okay. Admitted, claim to zakat admitted by the respondents.
My
Admitted by.
deeply obliged.
Most highly about my disposed of.
Right, please allow. Lordship, by way of this petition, Lordship, we are challenging an order of the largest CGM, Lordship, which was passed in.
Forget the manner in which the order was passed.
Okay.
They put the district judge remanded back the matter. So the chief judicial magistrate, he has visiting rights there
Lordship,
in the jail. He had made a note also
Lordship.
earlier. So he has passed this order. We'll not go into the jurisdictional part. Tell me, what right do you have to make that claim?
Lordship, the petitioners herein are.
Don't bring in culture and heritage.
Lordship, I'm not on, I'm only on the jurisdictional.
You asked for me that you must be given a little bit more proteinous material.
Lordship,
You must be given a better hygiene, a better, more good food. We'll immediately permit that. But why Tamil Pan?
Lordship, the issue here is not whether it's hygienic or not, Lordship, whether the CGM has the jurisdiction to pass the order.
We will go into the issue.
Lordship, that is the only issue I have at this point, Lordship.
We will not entertain that.
Otherwise, Lordship, the Inspector of Prisons has got the right to pass any order. The CGM has only the power to suggest it. Irrespective of the cultural part and.
Yes, who is for the inspector of prisons? You are there.
No.
You are for whom? You are
For High Court, Your Lordship.
Mr. Monto is appealing.
Yes, Lordship.
We want Mr. Monto.
Yes, Lordship. He has
He is-
difficulty today, Your Lordship.
Okay, we will want him.
Can it be?
I'll not go into technicalities. I'll go straight
for
to the
30.
issue. Why technicalities? Why remand it back? We will decide. Any problem in our deciding the issue? Whether you're entitled to have betel nut there.
It is otherwise not a prohibited.
Any other things you want?
Lordship, it is not under prohibited items also, Lordship.
It's not prohibited. It will destroy the whole place.
Lordship, the issue was with related to cleanliness of the premises. In fact, Lordship, if the Lordship.
And the one of the factors that has been highlighted is when the under-tried prisoners are brought, the whole room is gone. It's completely unhygienic, even for them.
That is.
So with these materials, can we? Because that is not a prescribed material. If it was so, it would have been from time immemorial, this would have continued. There are other items also where normally, in normal parlance, the people take as a part of culture. Those have also to be incorporated then. You understand what I am referring to
Lordship.
then?
Lordship, otherwise also, Lordship, in other districts, this item is not banned. This is only in relation to the district of Kamrup.
Other district, it's not banned. It's there. You have materials to that effect.
Lordship, I have pleadings to that effect. I have to say.
You have pleadings.
Lordship,
Where?
Lordship,
In the writ petition.
Lordship, I'll just go through it. I just remember once. In fact.
At least my scan did not get it. If you have it, fine.
Lordship,
Highlight it. When will Mr. Monto be available?
Lordship, today some difficulty. Yes, Lordship. Can it be
Uh,
called for 13, Your Lordship?
Yes, madam.
My lord.
You want this thing in.
Our affidavit, my lord.
You have given an indirect indication
Lordship.
that this should be introduced.
This is not the contraband thing, and my lord, that itself.
Now the
yes.
prison people will also buy indulge in this business? Is that what you
Partly-
want?
Partly I have seen in my lord 9, 10 and paragraph
Yeah,
11
that is there.
of our affidavit, my lord.
You are a, Mr. Counsel, you are a DAS.
Peters, Lordship.
PDAS.
PDAS.
PDAS. Heard Mr. PDAS, learned counsel for the petitioner. Also heard Ms. U. Das, learned additional senior government advocate appearing for the respondents number 1, 2, 3, and 4.
Or
Also, Mr.
T Gogoi, Your Lordship.
T.
T Gogoi.
T. Gogoi.
Yes.
T. Gogoi, learned counsel appearing on behalf of Mr. T.J. Mohanto, appears for the senior counsel, appears for the respondent number 5. It is submitted at the bar that Mr. T.J. Mohanto has certain personal difficulty from in attending a personal inconvenience, restraining him from attending the court in the matter. Also, accordingly, registry. When will it be convenient? After 15?
12 or 13.
12, 13 would be
13 will
difficult.
better. That's, yeah.
We'll have it on 22nd. Any inconvenience?
No,
No,
On 22/8/2024.
obliged.
I'm obliged.
You find out that other districts are doing this, maybe that may persuade this court. And by this time, you file this case when?
2016. Lord.
16.
Yes.
If they're not taking their, that habit has also gone by now. Yes, Mr. Das, what about the new decision,
Which decision? Well,
the latest one?
The latest one, we have challenged it as it's a per incuriam decision. We have referred it to the division bench. We
No,
have
no, I'm not talking about our division bench. I'm talking about the Supreme Court.
Supreme Court's latest decision, Malad, I have gone through.
Hmm.
That has nothing to do with this case because two things are there.
The criminal
the-
concept has been brought
No,
back.
no, has not been, it is an obiter. It is an obiter of
That's
Justice
for you
Gawai
to-
and 3 judges.
No. That
The
is
main
one of
issue
the.
is subcategorization and China's judgment, whether it can holds the field. The Supreme Court
So
rightly said,
China was one of your trump cards all along.
no. Malad.
Yes, you won one of your trump cards all
I
along.
never
Not in
filed-
this case, in other
No,
cases.
not China. No.
You were-
Because
you-
subcategory.
Because you,
doesn't come in the service case.
Mr. Das, your case, your arguments in those matters was that the reserve community as a whole is a homogeneous.
No.
I remember.
Malad, my contention was that reserve category were a class apart and creamy layer concept never applies for the past 75 years. And the 7-member judgment never referred any question of creamy layer. It is Justice Gawai and 3 judges who had made a statement.
That is the.
Observation, it's
Need
an
not be,
obiter.
Jarnal Singh is there. Jarnal Singh has been
I
reiterated.
am fully relying on journal 1, 2, and if possible 3 if it is coming. And that applies to OBC, creamy, till now. Let Parliament take a call.
No, I'll make it I'll provide for that. Don't worry.
May it please your Lord.
My lord, these
Now, where is the finance? Get the finance. Yes, what happened to that single bench, coordinate bench order? It has gone up on appeal.
Yes, it is gone because our thing is that it should have been referred to the larger bench in terms of Supreme Courts. If the judge differed with 3 judgments of the coordinate bench, Sri Bhogeshwar Saikia and Paresh Deka. So he overruled it and he passed an order. We have taken that plea and it has been admitted.
It has been admitted.
Yes. And your lordship was referring to on the last occasion,
Hmm,
before my learned friend starts,
hmm.
that day I could not give the judgment. Whether the OM of 2023, which came in, it is prospective or retrospective.
Hmm.
In the tax matter, my lord, the Honorable Justice Devashish Borua, he has held that it cannot be applied. It has to be prospective. Because you take away the vested right accruing prior to 23.
I think I should not be taking up this matter. I had argued that
Yes,
matter.
that was the thing I wanted to.
You could have told me that on the day go.
That day, when I came, my lord, I came reservation and promotion. But lordship said, let us.
My lord, only one thing, my lord. The crux of this case is different from other case, other reservation case. Here, my lord, the cadre state is 5. And this court has observed that in the cadre state of 5 of Joint Commissioner of Taxes in the state, my lord, there cannot be any reservation. And my lord, in the second case, which I have filed, my lord, this case has nothing to do with all this point of reservation. We will not argue on journalism or anything, my lord.
You will be on,
Only
Doctor.
only Rakesh Agarwal.
What doctor it was? Water resources?
Prohan.
My lord, I have annexed it with my writ petition, my lord. Rakesh Agarwal 20.
Rakesh Agarwal is subsequent. Before that, huh? No. Doctor, 2011 4.
That was on the,
Okay, so say again. No.
no, earlier was vacancy base.
Arre,
This
that
case
writ
is-
decision you went up on appeal. Ajorika.
Thakuria.
Huh? Viren Thakuria.
Oh, that is there.
What
From
was that?
water resources.
What was that,
Yes.
doctor?
My lord, it was written somewhere.
There is one.
2000.
My lord,
wait,
here
wait.
this question has arisen because the government stand. We didn't know. That day, Mr. Gogoi praised the minutes. We were not given a. There we find that I have been brought down on the benefit on the basis of the OM of 2023.
Huh.
Definitely, it has got a bearing because my entire argument will be that retrospectively you cannot do it.
My lord, where is the question?
My lord, that is a
retrospective, my
petitioner's
lord?
case.
My
I'm
lord,
talking
That
about
I know.
the respondent's case.
Mr.
My lord, lordship.
Let me not create a controversy for myself.
My lord.
Mr. Das is indicating to that extent that I should not be here. And I should also take that in a good sense. Because there is a decision where I argued, at least they can always take a feel that Mr. Das is already having that, I may be biased. So let us not proceed with this. There is no account of matters. There are enough matters for me.
Lordship has not proceeded also. So lordship, only one anxiety, we are.
Mr. Das is successful today.
He is very happy, my lord.
Very happy.
No, my lord, I'm not happy
He
because
is
my
very
client
happy,
has
my
not
lord.
got anything. My lord,
Already-
he should be happy because he could
My lord, it is
block
already.
my promotion.
But you have
for
no
2 years.
case. But you have no case, Mr. Das.
My lord, can you be
This matters before any other bench without me.
Will a lordship give a date or?
I'll not. Once I say no, it's no. Mr. Das,
We'll place it.
My lord,
Mr. Bursha will make it.
one thing, my lord. In both the cases, the interim order.
Interim
is not
orders
there.
passed earlier, full stop. However, as consented to by the Learned Council for the parties, the interim orders passed earlier to continue until further orders.
Well, not only it will come up before. Only
Naturally.
problem is that next week also same, the other honorable judge.
How
also
can
will-
you know what would be the bench next week?
My lord,
I
he
don't know.
knows, my lord.
I don't know. How
Regarding
can you
listing
know?
Of these cases, he knows everything.
Obliged.
Obliged, my lord.
Anyway, he's successful today.
My lord.
My work last night went down the drain. Anyway, we'll have another matter sometime. That is Dr. Water Resources. No, huh? No. 2011 4 GLT.
Doctor.
There is a decision that was taken wherein this thing was done. It was taken up on appeal. Mr. Das was there. Justice Goswami was
Goswami.
part of the judgment, part of the bench, and that judgment was upheld. Appeal part, I think you will get it in Rajesh Agarwal. The reference you will get it in
Appeared for
Rajesh.
Biren Thakur.
And there is.
You appeared for Biren Thakur.
There is another judgment, my lord, Vinod Agarwala, that is from Department of Cooperation in the same line. In the state.
I know, I
cadastre of
appeared in that
My
matter.
lord,
I appeared in that matter. Rajesh Agarwal, you will get that decision.
my lord.
Therein, that has not been changed in any of the decisions.
Exactly.
Because Mr. Das does not permit this courts to go to that decision any
My
time.
lord. Obliged.
Harshiba Asini. pending. It is.
It still very volatile.
And when Mr. Das is there, it will always
Mr. Das-
be. Have you heard
Das-
what he has said? That reservation matters are still vibrant. I said, Mr. Das is there, it cannot go down.
We had a beautiful lecture also on preserving.
এই চারটে platform board। চারটে কি করতে মজা হচ্ছে অফিস কপি গুলো লিখে
Lord, once I can quickly recapitulate, my lord.
Huh.
These are probationers, my lord,
Hmm.
6 in number. They were appointed in December 2021, my lord.
Hmm.
Then, my lord, against one of the candidates, my lord, appointed candidates, there was a challenge to his appointment, saying that,
Mr. Patwari and Mr. Deka.
yes,
Hmm.
they say that they ought to have been given an age relaxation, which they were denied, and therefore they should be appointed. Simultaneously, there was also a complaint by one of those petitioners pointing out, and the complaint did not really say much about the private respondent, but it said that they were deprived of the age relaxation.
Hmm.
Now, based on their, they say they undertook an arduous task of revisiting the entire selection process, my lord, not just confining to age relaxation, but also checking OMR sheets,
Hmm.
checking the experience certificates,
Hmm.
and they found that these 6 appointments were bad in law,
Hmm.
were illegal, and therefore they issued a termination without any notice whatsoever.
And in the first affidavit with pertaining to Mr. Patwari and Mr. Deka, they had taken a plea
Right.
that this clubbing cannot be done,
There cannot be a cumulative relaxation.
realization, but which they have rescinded subsequently.
Subsequent. Now, my lord,
And you had also raised one issue that these being things prior to your recruitment, whether without there being an unsatisfactory service, finding on that, whether those aspects could have been brought in to,
Right.
so you were supposed to place some judgment.
Yes,
today.
yes. My lord, since the APSC decision had come up on the last occasion, my lord, I'll just begin with that and show, my lord. APSC.
Radhesham Gupta and all are relayed by you. Chakradhar, Radhesham, all by you.
Lord, how I seek to distinguish this particular judgment in Gitali Dole, Lord, which is the APSC matter.
Hmm.
If your lordship sees para 43 onwards, my lord, there were basically 2 grounds for discarding the plea of the petitioners, if I have understood it correctly, my lord. First, at para 46, my lord.
Hmm.
Para 46, my lord, if I may read.
Hmm.
Clearly, the allegations of irregularities on the part of the petitioners
Hmm.
are not allegations of any irregularities, negligence, inefficiency, and misconduct taking place during discharge of their duties, post-recruitment, or having been appointed to public offices. The allegations against the petitioners in indulging in gross irregularities and fraud involving payment of illegal gratifications for securing appointments to public offices are apparently of pre-recruitment period, that is before they were appointed to public offices.
Hmm.
In the understanding of this code, the element of misconduct which reverberates in the submissions made on the behalf of the petitioners is attributable only in respect of a period subsequent to a valid initial
sir.
appointment.
No, we group me. Thank you.
Not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during the recruitment process and or appointments had been made and or before a person is born into a cadre service would constitute misconduct. A vain attempt was made when Reliance was placed in paragraph 37 of Palak Modi Supra to say that the use of unfair means in the evaluation test, confirmation test would certainly constitute misconduct. Reliance so placed vis-a-vis the facts and circumstances in the present case is altogether out of context. In Palak Modi, the private respondents therein had already been appointed as probationary officers way back on 5/5/2006. In due course, the State Bank of India informed that they were due for confirmation in service, and therefore they are to appear in the test proposed to be conducted on 27/2/2011. The private respondents appeared in the test held on 27/2/2011 but the names did not figure in the result declared on 10/5/2011, primarily on the ground that the Institute of Banking Personnel Selection, which body was entrusted with the task of preparing the examination papers and evaluating the answer sheets, submitted a report to the bank that some candidates, including the private respondent, were suspected to have used unfair means. Thus, para 37 of Palak Modi, which makes mention that use of unfair means during evaluation test, confirmation test would constitute misconduct, was only in respect of the test conducted for the purpose of confirmation in service. No law was laid down in Palak Modi that misconduct can also be stretched back to a period prior to entering into service and for illegalities and irregularities committed during the selection process. As misconduct cannot be a recruitment, pre-recruitment phenomena, the very bedrock of the submissions made on behalf of the petitioners, that the impugned action being founded on misconduct, therefore the principles of natural justice and or provisions of Article 311 of the Constitution could have been made, could have been dispensed with in the considered opinion of the court does not hold any water. Now, my lord, I'll come back to this point, my lord, but before that, now, here in this case, my lord, all the materials and were placed, and ultimately at para 52, if your lordship sees.
No, Palak Modi, the distinction was, Palak Modi will have got no application because that was something after the people were
correct,
born in service. So
Correct.
Palak Modi
So
will have
it's
no.
not a pre-recruitment
No.
misconduct. That is how Palak Modi was distinguished. Now, para 52, my lord, the second ground, which I believe was the reason for disagreeing with the petitioners, on the above, after all those charge sheets, investigations were discussed, my lord. On the above, first and foremost, the circumstances resulting in the discharge of the petitioners from service are undoubtedly exceptional. Sham examinations involving the petitioners in main examination and their selection and appointment through an illegal process is the basis of their removal. The foundational facts, as observed in the preceding paragraph, in the opinion of the court, were sufficiently compulsive to take the petitioners out of their jobs. There was need for promptitude in taking stringent action. Urgency of the situation also demanded weeding out those identifiable persons who had entered into service through an irregular and illegal process. The Odi Alteram Partem rule tested on the exceptional facts and circumstances of the present case is not applicable, and the petitioners cannot be heard to demand an opportunity of hearing or to claim a right for a post-decisional hearing. The disturbing disclosures in the investigation reports with regard to prevalence of unfair procedure and tampering of examination process for the benefit of the petitioners brings the present case within the category of exceptions to the rule of Odi Alteram Partem to reiterate their sufficient, reliable, material, and foundational facts to reach a finding that the examination process involving the petitioners in the main exam was vitiated. The petitioners also cannot be heard to say that merely because they would be deprived of salary and allowances, the impugned actions have visited them with civil consequences. A discharge from service founded on misconduct and without opportunity of hearing may inflict a person with civil consequences. However, when it involves discharge from service not founded on misconduct or on the ground of grave illegalities and irregularities as indulged by the petitioner at the point of time and their selection and prior to entry into service, there cannot be a contention of infliction of civil consequences. Now, my lord, the second point, my lord, there were foundational facts laid before the court, my lord, and the court took note of the admissions made before the investigating officers, the revelations that surfaced, the testimony of the witnesses, and considering all of this, the court came to a finding that this is an exceptional case where the magnitude is so big that to ensure that public faith on the sanctity of official posts is not disturbed. So therefore, the stringent action of discharging was done without complying with the rules of natural justice, my lord. Now, in the case at hand, my lord, if your lordship takes up the affidavit in opposition filed in any of the matters, my lord has Pranab Pathak probably.
No, you just refer.
My lord, para Q onwards, my lord, they sort of say how
The first
the
affidavit or the subsequent one?
the first affidavit. There's just one affidavit.
One, 2, 4. Okay.
If your lordship has Pranab Pathak, your lordship can take up running page 62.
Yes.
So this is how it began, my lord, para O.
Hmm.
that on 28/2/2022, a letter bearing reference number was issued by Vigilance Department to Mr. Prashant requesting to verify the ownership of the first complaint dated 2002. They've craved leave. P, if your lordship sees, then on 7/3/22, a letter was issued by Prashant to
Confirming
Vigilance
that.
Department
Then it
confirming
starts
the-
from Q.
Yes, confirming the ownership of first complaint that the instant letter was received by the Vigilance Department on so and so. The respondent again craves leave, my lord. Then Q, my lord, that on 25/3/22, a case bearing reference so and so was registered, internal investigation was carried out, my lord. They have again craved leave, my lord. Then again, the charge sheets have also not been produced. So unlike what transpired in the APSC case, my lord, where there were sufficient materials, convincing materials which prima facie led to a conclusion that there is something fishy that is going on in the examination process, recruitment process, my lord, which is why it was said that these are exceptional circumstances having foundational facts and materials having been already brought in record. In fact, there's a paragraph where they've referred that these pleadings were exchanged between the parties and they had sufficient notice. Nothing of that sort has been introduced by the respondent in this case, barring a particular the complaint itself and the office memorandum of the CVC. That, if your lordship finds at page 93, first the complaint, my lord. Page 93 is the complaint and extra R2, my lord. Now, in this entire complaint, my lord, they are not alleging any sort of illegality or foul play, my lord. They're only ventilating their grievance that we should have been given cumulative age relaxation under both the clauses, and therefore this their rejection of candidature was bad. Now, if your lordship may come to page 96. 96, if your lordship has. My lord, this CVO may please refer to a letter so-and-so dated 9/11/22 on the subject above. The case has been perused by the commission. Considering the facts of the case, the commission is in agreement with the CVO and DA IOCL would advise initiation of penalty proceedings against 7 numbers. Then point 3, CVO IOCL is advised to take decision with reference to further investigation by external investigative agency as per para so-and-so of the vigilance manual. 4 is important, my lord. IOCL management is advised to take action at their end with regards to 7 wrongly selected candidates and against Anshuman Bora as deemed fit as per recruitment policy. Now, my lord, action is advised against 7 plus Anshuman, that makes it a total of 8, my lord. Now, terminations have been issued only in respect of 6, my lord, and there is absolutely no explanation, no disclosure as to what happened to the remaining 2.
Anshuman proceeded. Again, against Anshuman, there is a termination.
There's a termination against Anshuman and 5 others. So 2, we are not sure what really transpired.
Basically, if I've understood you correctly, what you want to say is, by relying on para 52, that in para 52, there were materials which connected the appellant or the petitioner therein with the allegation of a foul play at the time of recruitment. And this court held that that may not be a misconduct, but given the foundational facts involved and the direct involvement of the petitioner therein, this action was taken. But on the ground of so-and-so, there cannot be a contention of infliction of civil consequences. So civil consequences, that point has been brought in only to establish that there ought to have been a hearing provided to them before an action is taken. Now, if we apply that to your facts, right, you are not placed at the same level with regard to the allegation like the petitioners in Gitali Dole and other cases. Mr. Chaudhary was very categorical in saying that he has not leveled any allegation against you. But Mr. Chaudhary says that if we accept the complaint of those two persons, the natural corollary would be you are out. Right? They are also before us. So their prayer, we'll have to give it a consideration. Now, if we consider their prayer, subject to what happens, and we require the IOCL authorities to now consider that what happens with them, the end result would be you will be ousted. Now, by entertaining your petition and directing them to put you back, and at the same time requiring that exercise to be carried out, would it not be an empty formality?
No, my lord, I would look at it this way, my lord. My lord, here allowing their writ petitions, if your lordship says.
Because the posts which are available, we can't go beyond that.
Sorry,
So if they have to be accommodated, you have to go.
yes.
Or you show me that, no,
Just to factually, not they, either of them,
either of,
even he will be assuming, because they were prevented at a particular stage in the selection process. The last stage, SPPT test, they could not
now,
appear.
there are only two candidates who are there.
Two are there,
Hmm.
plus Mr. Decca's client will continue to remain in the fray. In the next stage, which Mr. Decca's client has already passed through, if they are not able to meet the requirements.
So tell me one thing, Mr. Chaudhary. If that was the situation, you could have delayed his confirmation. Why did you interfere? Why did you set aside his?
Because it was erroneous.
Fine, I got it. Erroneous is again not replaceable. He is not immediately replaceable.
The moment we find that he has
I think
admitted position now.
there is a level of selection to be crossed by Mr. Patwari and Mr. Decca's clients. Mr.
True.
They have to cross a particular level. Now, if they don't cross that level, his appointment gets regularized.
No,
His-
it is. Those two persons
Hmm.
have scored much higher marks. And he has scored marks which are much lesser, particularly Kwa, one of them.
Hmm.
He would not have got to that position at all. And the very fact that these people were totally erroneously ousted, the axe had to fall on him.
I got it. But the stage has not been reached insofar as these two
Those
candidates
two are
are
concerned.
concerned that they are entitled to a job.
They may not-
They may not be also.
Your Lordship,
What I'm trying to project is, what was the rush without carrying out that exercise to set up these people out?
Your Lordship will kindly look at the facts as a whole. Now, the ball was set rolling by virtue of a complaint. And they not only filed a complaint, they also approached this honorable court.
And okay, you are saying that everything is based on that CVC thing.
Not just CVC. First, we had an internal investigation. First we felt that there is something suspicious going on.
Hmm.
Once that happened, we referred the matter for more transparency. It was referred to an independent agency. CVC steps in. CVC undertakes the whole exercise all over again and finds that out of those 40 odd selections that we made, there was a problem in the and these are based on those similar foundational facts, Madam. As in Dole's case,
No,
it is, Madam. There is nothing attributable to them.
that is the difference.
That is the difference.
It's a
But-
mistake committed by you.
Yes, my office. So what do we do? Your Lordship will kindly come to the, my learned friend was placing page 96. Your Lordship will kindly come back to page 96, Madam, our affidavit.
Hmm.
This is what
This is the Bible for you. which led you to the further
I
action?
wouldn't even call it, this was the second stage. First stage, we had our own internal investigation. And then for further transparency, we said, let an independent agency investigate. They did so. And based on this, they,
What is the date of your release?
17/12/23.
So, Mr.
17/2/23.
17/2. So, as on 17/2/23, after 21/23, the rights of either J. Patwari or Mr. Deka were not crystallized.
To the extent of appointment may not be, but to the extent of their ouster.
They have come in. So an exercise is required to be done. To that extent, no dispute. An exercise is to be done. But that exercise had not crystallized. Their rights have been recognized, but not finally crystallized. Why were they interfered?
That is the reason I was.
Because why I'm telling you, IOCL management is advised to take action at their end with regard to 7 wrongly candidates and so as deemed fit as per its recruitment policy. Now, the CVC, while making this recommendation, was also aware that they were appointed and they wanted action as per your recruitment rules. Right? Now, today, a situation has come across. Tomorrow, for some reason, one of those candidates he is really effective, does not make it. For some reason, his whole thing falls to. Otherwise, moment he goes, his thing gets regularized because there is no other allegation.
There's no allegation against him. We have
No.
been very clear, right
Even
from the
his recruitment, there is no allegation. So why did you interfere?
The reason is this, Madam, para 4. He was not had he been an isolated case, he was not an isolated case.
7 plus 1, 8. And Mr. Deka consents that this action was limited to 6.
No, there are two, in all there are 7. 6 are before your lordship. 1 has deemed it not to come to the court.
So 6 plus 1, 7. There is still 1 left.
1 has not come to court.
No.
7
plus 1, 8
no,
candidates.
That is the incorrect language employed. So Angshuman Borua is included in this 7.
Okay.
All the other 6 have come before the 7th has accepted the termination.
Okay, fine. So you mean to say it was only 7, not 8?
Not 8. So, and terminated the other 6. The others would have.
No, I would have. It would have been a situation if, in respect of the other 6 also, there would be candidates to replace them. If there were candidates, we don't find candidates to replace.
There would be candidates who would come up.
Huh?
People who have scored. In respect
They have
of
not come up.
No,
they have not come up.
They haven't because we have.
Because why I'm saying so, Mr. They were appointed at least 2 years prior to this incident. They were about to have their probations done. The select lists in question, 2 contingencies. 1, their appointment. So insofar as that list has become invalid, but in respect of Patwari and Deka, we'll check up. If they have come within the validity of that select list, that gets extended. Who them, not others. Whereas the others, other than Mr. Deka, the other persons, none has come up for a challenge.
No. Because
so why they were also brought within this? It would have been a situation where some aggrieved person has come up before you. Right? Now, for a fault on your part, which you don't attribute any malafide or any connivance on their part, you have interfered with their services.
Because if we allow them to continue,
No, you should have allowed the writ petitions filed Mr. Decca and Mr. Patwari to proceed and thereafter taken in terms of that, taken action.
That is.
You have put the horse before the cart.
My lord,
Cart
this-
before the horse, sorry.
to this, my lord, my answer is, this is perhaps another way of looking at it. We have,
That is the proper way. Because
is
a
it?
proceeding having been initiated before this court, we being in session of the matter, why did you precipitate the
There is-
further?
Your lordship will, the reason is very simple. There is no protecting his termination. Had there been any protection given to him, it would still have, we could have agreed.
We understand.
Had there been some order in the first two cases,
Mr. Chaudhary, today, I am in hindsight. I have the materials to look at. When the matter was first before this court did not have these materials. So today I am better placed.
Yes.
While hearing the matter, then the coordinate bench was considering the matter at that point of time.
absolutely.
At that point of time, admittedly, the allegations qua Decca and the writ petitions, naturally we will draw an impression that this is correct. But today we find there are two compartments. One wherein Decca, Patwari, and both Deccas and Patwari is there. And another wherein only those 5 writ petitioners are there. Against them, there is nothing.
I'm sorry, my lord, again,
There is against them, there is no challenge before this court,
yes.
right? If that be so, why have you interfered with them when it's a mistake of yours?
Because those were erroneous appointments. Fundamentally. your
Because
lordship,
nobody has come
what
up before
happens
you,
to-
Mr.
does not matter. To that, my answer is, Article 14 and 16 gets violated in respect of people
No,
who.
I would have understood. I would have understood that situation if it was within the validity of the select list. This had come to notice and you had taken some steps. Then you could have gone back to your select list. Now it's not even permissible. Those posts you will have to re-advertise.
Will re-advertise. That way, we protect the guarantees under 14 and 16 of all citizens uniformly. They again get an opportunity.
What are the nature of the penalties issued, madam? To your officers who are
lordship, on the
guilty?
chart, we have prepared a chart.
Just show me that.
So, we have prepared a chart.
I just wanted to know the,
Yes, yes.
the penalty that was imposed. Because
Each of the officers, we have prepared a chart. First is Parinita Sonwal. Your lordship will find the penalty imposed is,
what is the penalty
what are the
imposed?
charges? Also, we have indicated.
What are the penalties imposed on this?
It is at the next page. Withholding of 1 annual increment,
Oh,
pay with cumulative effect.
oh, big penalty you have done. Whereas these people have been thrown out. And the person
Your
responsible.
lordship will peruse the next one. We have withheld promotions.
But
depends-
that is, it should have been termination. Because the way you are projecting the matter.
No, that is where, my lord. These were initially alleged that you have done it deliberately.
You come down, come down, come down. Miss Arshita J. Topo.
Yeah.
With major penalty, withholding of promotion for a term of 200 days.
Because their
Promotion
intentional-
for 1 year.
what is the extent of proof? That also we have to see.
Mr. Chaudhary, the end result is a interference with an appointment on the ground that it was erroneous,
Yes.
done by persons. Okay, erroneous. So it is ousted, but the person who has done it is not being judged
Your
in the
lordship-
same manner.
Your lordship will kindly appreciate this. We initially thought that these errors, when we charged the officers, we were under the bona fide belief, and accordingly they were charged that you did it intentionally. When after the proceedings, we found that in some of them that intention to confer benefit on some person could not be established. That is how this came to be.
So if that be so, if it is a human error, why these people should suffer?
Well, because
And provided, forgetting DECA, the other, there is no challenge.
if because of a human error, the right under Article 14 and 16 of another person gets violated.
Who is that person? It's a
Person who-
presumed person.
Person who got higher marks.
No, it's a presumed person. He is
No.
not having any grievance.
It's not presumed so far as our records are concerned. Because
Have you informed him that we will appoint you?
we have held back at that stage, showing due deference to this honorable court. We will.
How will you?
If
How
the-
will
If the
you?
law permits, we will.
How will
Or
you?
else we'll go for a fresh advertisement.
That cannot be. That cannot be. I think, Mr. Chaudhary, you will have to examine this line. Because DECA, the termination is bad because it is in haste. Till the rights of the other twos were not identified. Insofar as the other 5 is concerned, I don't think so. This court is going to,
I'll address your lordship. Your lordship will take a call.
I want to, because what I'm trying to tell you is a tentative view. Please don't take that. I'm trying to say that this is something which has come. I want you to address on that.
I'll address your lordship. For us, your lordship, while exercising powers of judicial review, is examining the decision-making process. Now, what is the decision-making process? we have got to-
I am also required to look into a grievance raised by at least 5 petitioners. I'm forgetting DECA. Against whom there was no grievance raised by any of the selected candidates.
Appreciate it.
Now you are holier than thou, that's okay, fine. That you do it in a particular manner, that is fine. But whether that was called for in respect of those 5,
I'll-
1, 2, in respect of Mr. DECA, as you have yourself admitted that Mr. DECA and Matwari were required to cross one more level.
But
Whether before crossing that level, because once it is not crossed, his appointment gets regularized. Even if there is some inconsistency, if they are ousted, he gets regularized. Right? Interesting.
Your lordship,
Kindly address me on that.
yes. To that extent, if that is the extent of, assuming, hypothetically, I'm not.
No, I'm not on that. I am on the process.
Yes, sir.
And now considering the emphasis you had given, why you wanted it, and the action you have taken consequent to that. It only a
Your lordship.
basically human error.
Your lordship will kindly appreciate one thing.
And also
Is it,
the extent I can go to, I want you to address that also. Whether I can go in this line.
my answer? We have resorted to a absolutely transparent process, and we did not even merely go by our own investigation. We referred it to a independent agency. Independent agency does its investigation and finds that there have been errors at the level of it. Which means the rights guaranteed under 14 and 16 of some XYZ candidates were violated. So these appointees were in violation of those rights. So therefore, what we did, we said that we are not attributing anything to you. We are not, even at this stage, we are not saying that you are in any way
That is the
responsible.
difference between Gitali Dole and this
Yes.
case.
Absolutely. So we are saying that your entry was improper. And at that stage, had it been a regular confirmed appointment, we would have resorted to a disciplinary proceeding. But here, we find that there are provisions.
And again, I want you to address me because you said this is a decision that you have taken on the basis of the conclusions and directions given.
Not direction,
Not recommendations made
recommendation.
by the CVC, an independent body. CVC required you to take this decision in terms of your service regulation. Now, show me a power in your service regulation to take an action in this connection. Please don't revert back to the action in Gitali Dole.
No, I'm not even referring to Gitali Dole. In fact, in my humble understanding, it is
Leave it. I know what you're going to say. You need not say that. But once the action is required to be taken in terms of your service regulations, show me
That is
under your service regulation, where pertaining to confirmation,
Mal,
whether this aspect is also included.
expressly, your
Not.
lordship, no, your lordship will never find a set of rules which
That's what I'm
says,
saying. That was
which
I
says that there will be illegal, in case there is
No,
illegality.
in the APS ACS rules, there is a provision to that effect.
Here, my lord, we fall back on clause 3 of the appointment order.
Yes. Page.
Page 35 of the writ petition. That is why, my lord, ultimately the law relating to probationer and termination comes in. Unlike in many other provisions, we have in fact categorically inserted this provision that an express order of confirmation will be required.
No doubt on that. No
And
doubt
then,
on
your
that.
lord-
That is why when I said, Mr. Chaudhary, in lieu of terminating them, you could have extended their confirmation period, probation. Because until and unless you issue a letter, they'll not be confirmed.
So, during this period, we find that there have been errors, may not be attributable to them, but that ended up depriving.
Because I'm finding it difficult because this clause 3, 35, when you read it with page 40, para 2, page 40, para 2, termination order.
Well,
This again, you go back to their selection.
Yes.
Per se. CBC required service regulation. Show me a service regulation wherein even there is a interpretation can be made that this can be done.
the probationer, we can always first see.
Why I'm saying so,
My lord,
whether he was entitled to a notice to that effect.
that is, those are the judgments I'll place, my lord. When it comes to probation, your lordship is aware of the law. A probationer has absolutely no right whatsoever.
Yes, if it is in terms of clause 3 of the appointment order, he will have no right. The only right he can have is to approach this court, make materials, bring on materials record, asking us to lift the veil.
And
And if we lifting the veil, we find that this is still that, fine, that's the end of the matter.
your lordship will at the same time have to also look at what had already fallen from your lordship. Will it result in something else? Because the facts are facts. Those facts.
That is a question which I have made to Mr. Decca.
Useless formality theory will
That
automatically
is
come.
there.
Can change it.
Once they both they exercise their rights and we adjudicate and crystallize their rights,
Exactly.
that question would
Automatically
stare at-
come up.
But till that period of time, whether the termination was proper.
That problem can be, while exercising powers under 226, your lordship can always
Mold.
mold, saying that in case those two fail at the next stage of SPPT, automatically his rights will come back. And your lordship can always direct that he will be taken back with
Fine. That is one way of looking at it. That will save public money also. Fine, I accept. But with regard to the other 5,
other 5 materials show. Now, assuming
you are appearing for the other 5 also.
materials show that there were persons who had got higher marks. Now, the moment these litigations are closed,
Mr. Decca,
we may give them an
do some more research. There are these judgments of the Supreme Court that on presumptive rights of somebody being violated, a person should not be. I did not get time yesterday. I would have. Mr. Chaudhary will bring it on record. And Mr. Chaudhary, please, while you are addressing me, also address me on the question of my rights, of the limits that I should not cross. This, as an officer of the court, I am required.
In fact, those judgments, in fact, one of the last ones, that 2007 judgment, where the Supreme Court said that when it comes to errors or irregularities or illegalities at the entry level, There is no question of any notice, because if the facts established, then it will be a useless formality, following that Aligarh Muslim.
No, that in case of Mr. Decca, qua there, I accept. But in the other,
Others,
I'm finding it
again, the
difficult.
facts cannot be changed. Assuming those 5 are not before your lordships. In their place, if we, there can be 2 situations. Either we fall back on the persons who have scored higher marks,
you
they-
cannot today.
or else we re-advertise. Either way, the guarantees under 14 and 16 of the citizens at large gets protected. So your lordship is having it on a different day.
Can you work on that lines? Work it. Very interesting debate. Madam, let off very that mountain that you showed us on the other day turned out to be a molehill. Unfortunately.
I'll try to reconvert it to a mountain on the next occasion.
We'll finish it off next day. You give me a date wherein we can take the whole day if required and then finish up this.
Your lordship, I believe, is available here.
I'll not be here from 19th.
In that,
Can it be on 3rd or the 5th?
5th would be ideal.
5th
because
would be
I get
ideal.
away.
I 4th also I get a date to just recapitulate.
5th would be ideal.
5th, okay. But the learned council आगे का order में लिखा ही है. Mr. Okay, Hardy Learned Council for the parties at length. Post of hearing remains inconclusive. The list again, as agreed to by the parties, list again on 5/9/2024 for further hearing. Full stop. Work on that lines. And Mr. Chaudhary,
Yes.
while you are arguing, I don't want to exceed my jurisdiction also.
Will it come as a partner?
It would be further hearing. But
Your
there is one judgment while arguing that a PSC matter had come across. I'll try to find out as to how the
In fact, that
recruitment things
in fact,
has to be. Huh?
in fact, Lord, in that judgment, with utmost respect to this, noted that no decision has been cited where it relates to pre-recruitment. However, Mr. Anand Kumar Bhuiya had referred to a judgment where it was the same at the entry level.
Entry level. Somebody had referred, I know that.
in the Inderjit Singh Kahwa, that is where
Hmm.
the Supreme Court said that if the fact of irregular or illegality in the entry is established, then that is Inderjit Singh Kahwa, 2006. volume
And no
11.
notice is required.
The rider is that the facts have to be proved and established.
How do you prove and establish without the person being
No.
also brought in?
Here, assuming I have brought it, he cannot say anything about.
Your thing is that he comes in or doesn't come in, the end result would be the same.
Exactly, because the calculations cannot be changed. Calculations, we can produce the records, your lordships can have a look. Those 5 candidates where there were errors in adding up the totals or manipulation in the
These
ownership.
people, officers you have proceeded against, they may have submitted a reply saying that it was a pure unintentional error, human error.
And it was not in respect of the entire, that is why one fact gains a lot of significance. There were 40 odd posts. Only 7 have been terminated because errors were found in their case. Others we have not touched. And they are working. They have most probably also been confirmed.
Why the same people were involved in the others also?
Yes,
Why only in respect of this 7? Such,
that is how we realized that these were perhaps even.
you have proceeded against them,
Perhaps,
but you have not been able to come. So if it is just a pure and simple,
that's what
not an APSC sort of a situation, but a pure and simple human error. Now they having worked for 2 years, not Mr. Decas, first client, others. Why, take a call. Why would they not be permitted to continue? Deca will take care. Who are Mr. Patwari, because Patwari and
Because
Deca,
that
they
would-
have a,
that would amount to allowing people who were otherwise not entitled to.
can't help it because there is no challenge to that. Nobody has come here
But-
and asserted their rights like them.
But even if someone does not assert,
Hmm.
the fact that based on
So it was a further case then, at least in respect of those 5, to give them a notice, at least informing them, and they could have come up and contested the matter on this line. See, now that we have come in, the select list having expired, you can consider our cases for continuation because nobody has come up with a grievance.
we might, if the law permits, we might still revert back to them. Once the litigation is over, once your lordship conclusively closes these cases, we may still. revert back.
Why should I leave it to you? Why will I not do it and ask you to
It-
go before
the
the
op-
division bench?
The options would be either of these two. Either we go back, if the law permits, if the rules permit, we will go back to those persons who have been.
It will not, because that list is no longer there.
No, we'll have to check up whether the list is valid or not.
Subject to what?
Otherwise, what we
They have already done that, problem.
no.
That is understood.
If we re-advertise, they will again get an opportunity. Everyone gets an equal opportunity.
A leave was taken to advertise, and my information is, they have been re-advertised.
Of recruitment done.
Yes.
No,
No, recruitment not done, but there has been an advertisement again. Because there is an order, which my learned senior had insisted, that initial order said, do not fill up the seats. Second, they said that we will let us proceed with the advertisement, we will not finalize.
Fine.
What we have said, what we have prayed for, what? Let the embargo be lifted so that if necessary, we can call the people who have been legitimately denied.
5th, I'll try to be free on that day, free on to content. That in terms of the conditions spelled out in the said advertisement, an applicant to be eligible, Anganwadi helper to be eligible to apply against the various posts of Anganwadi worker put up for recruitment therein has to be in continuous service in a Anganwadi center within the same revenue village wherein the Anganwadi center, wherein the post of Anganwadi worker had so a vacancy against the post of Anganwadi worker had so arisen. So it is further stipulated therein that a Anganwadi helper of another village shall not be allowed to submit her application for upgradation against any post of Anganwadi worker so arising in Anganwadi centers situated beyond the revenue village wherein the said Anganwadi helper is so working. And even if such applications are so submitted, the same would not be accepted. Okay. Yes, now you can study.
Annexure 4 is the other two advertisement they have challenged. Page number 18. One is 8.7, other is 18.7. Same advertisement
तुम लिखा है ना?
Page 20. Page 20 same condition.
8.7.22 advertisement is 8.7.22 and 18.7.22.
Two are there. Lost.
Yes.
So kindly come to the commissioner's affidavit. From that, sorry. Lordship, page 53, Lordship. This is
53.
53, Lordship.
You want which paragraph?
Yes, from middle lordship. While we have been concerned about.
Tell me
providing-
the paragraph.
Lordship, paragraph, third paragraph, 53, the affidavit shall be the commissioner. The communication of ministry,
Who has sworn that affidavit? Parthopratim Majumdar? No.
this is, yes, yes, yes.
Huh?
Yes,
Parthopratim Majumdar, internal page?
53,
Huh?
53, 53.
No, you tell me the internal, there's some difference here.
Annexure 1.
Oh,
Another one.
Annexure 1,
is
okay,
the
okay, okay.
From the middle lordship.
While,
While we have been concerned about providing some opportunities of further growth to Anganwadi workers, it was never thought of the Anganwadi helpers in the same way. It has therefore been felt that similar opportunities in the case of Anganwadi workers should also be provided to Anganwadi helpers to motivate them to discharge their functions more efficiently. Accordingly, a decision has been taken to reserve 25% posts of Anganwadi worker to be filled up from amongst the Anganwadi helpers who have put in minimum 10 years of satisfactory service and also possess the requisite qualifications, that is age, education, etc., as laid down by the concerned state governments or oblique union territory administration for the selection of Anganwadi workers. This will apply in respect of all existing vacancies. Well, this is very important, Lordship. Vacancies of Anganwadi centers, Anganwadi
workers.
Anganwadi workers, and new vacancies arises out in future in newly sanctioned Anganwadi centers. The guidelines issued by the ministry in the post that the Anganwadi workers and helpers should be from the same village would be, however, have to be adhered to while giving effect to this new policy initiative. So, Lordship, from this,
Mr. Council, this is just a guideline,
yes,
a policy.
yes,
That okay, fine, you
Yes.
can recruit, fill up this post.
yes.
But the power is with the state.
Yes, Lordship. And paragraph 2 of the affidavit.
Same affidavit.
Yes, paragraph 2 of the affidavit.
Hmm.
That it is stated that the Ministry of Women and Child Development, Government of India requested the states or union territories to be issued suitable instructions to reserve 25% post of Anganwadi workers to be filled. Lordship got it? Filled amongst the Anganwadi helper at letter dated 6/10/2006. In pursuant to the said letter, the government of Assam issued a notification so and so dated 4/3/2013 to implement the decision in the same spirit and with the same objectives, subject to fulfillment of conditions as stated in the notification.
That is at page, that is annexure 2 to the
Yes.
affidavit.
Yes, Lordship.
Yes.
So, Lordship, as per my humble understanding, though the vacancies, Lordship, within the ICDS project, any existing vacancies, it must be applied 75%, 25% ratio. As per the pillar heading of the.
Have by this application of these rules
Yes,
or the advertisements that are under challenge, has the ratio of 75-25 been disturbed?
Okay.
Has the ratio between 75-25
yes.
been disturbed? Has it been disturbed?
Lordship, otherwise, yes, Lordship, there is a 20 post.
No, it will not be on vacancies. It will be on the cadre strength. 75-25 under ICDS project.
Yes, yes.
So if it is under ICDS project, then there has to be on the cadre, not on the vacancies so arising. If one vacancy arises,
Yes,
it will never be filled up by upgradation.
yes.
So there will be you can't divide that 1% vacancy, 75%, 25, you can't make it. So it has to be on the cadre. Once it is in the cadre, 25% is the limit within that, what do you call that, ICDS project.
Yes,
Now you as an applicant,
yes,
you can only apply in an ICDS project within your village.
yes. Harvard.
Same way, helper,
Here I just point out one thing, but he is a aspirant for direct recruitment.
I know that. I know that, I know that.
In-
You
in-
can only apply, even he can apply only within that village area only.
Yes, revenue. village.
Not the village area. He is a direct equity, only within the survey area he can apply. Yes, Anganwadi, particular Anganwadi.
Now the law has changed. Earlier it was village,
Matlab-
earlier
matlab the-
decisions.
matlab the Anganwadi center has a specific survey area. And 2-3 Anganwadi center may be in a village, in a revenue village. So he cannot apply in set the different
Okay.
survey area.
Okay,
And matlab,
but
this-
his application is also limited.
matlab here his challenge is.
I'm saying is that he say is a resident of coverage area of Anganwadi A,
Silghavdi,
which is again within a revenue village,
within a
particular revenue village,
Yes,
R1.
Lordship.
He can apply only for A.
Only for A.
If there is B, C and D there, he cannot apply because that is beyond the reach.
Survey area.
He can also apply in a revenue village R2, which is out. Insofar as helpers are concerned, they can, if there are A, B, C, D, Anganwadi centers in revenue village R1, and she is working in A, vacancy arises in D, she can be considered for that.
That is made.
A relaxation given
That
for
is-
upgradation.
That is made because they are already having experience and matlab, if then otherwise, if one person is kept only within the survey area, then if she is not eligible, ultimately it will go for directly. Then the percentage cannot be maintained.
And this limitation may be because of this within two or three different Anganwadi centers, the movement is permissible because otherwise a person is appointed, an Anganwadi work helper is there. She may not at any point of time get an opportunity. And there being only one post, one Anganwadi, upgradation may also not be permissible.
Not be permissible, and the educational qualification and all these things that may not be there.
Okay.
And matlab, the challenge made by my learned friend, matlab, had the petitioner been a working Anganwadi helper
Then it would have been a different ballgame.
of a different revenue village, then the whatever he is submitting, that it is confined to only one revenue village, then there would have been some justice.
I got it. I got it.
The basic issue in that petition, the advertisements were stated only on that grounds.
Now you tell me one thing.
Exceeds.
You are trying to be technical. Let me be also a bit technical. You come to annexure 2.
Yeah, Lordship.
No. Come to annexure 2. Come to annexure 2.
Yes, Lordship, yes,
Come to annexure 2.
yes. Definitely, I am, Lordship.
03/2013.
Yes, only one.
Okay. But have you challenged this? This is a policy decision. This is a policy decision of the government, and your
Lordship, annexure 2.
6.6 also says that everything would be in terms of the state government union territory administration decision. Have you challenged this?
No, Lordship, since it says that with the same speed and objects, the commission was from the affidavit. They saying they with the same speed and objects.
That's what I'm saying.
Yes,
If you don't challenge this, how can I entertain? How can I examine this?
no, Lordship, 75%, 25%, Lordship, which is for existing vacancies, Lordship. Otherwise,
That is a guideline. Then it says it will be on the state government to implement that. They have opened a path. Central government, Union of India has opened a path. That okay, you can do this also. Now, that this also is formulated by the state government in the form of 4/3/2013.
yes,
If there is anything here, a challenge has to be present.
no, Lordship, they admit that they followed the 6/10/2006.
Okay. You say there is no requirement for any challenge to this. That's
No,
your
Lordship,
case?
they admit by their affidavit, Lordship, that they have followed that guidelines.
No, but here there is a wrong, it's a prescriptions are contrary to what is there in 6.6.
Otherwise, Lordship,
Because 6.6 says filled up from so-and-so who have put in, according to this has been taken to so-and-so, filled up among so-and-so, 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 as laid down by, as laid down by this center for selection of Anganwadi workers. So whatever prescription is there for Anganwadi worker, that will apply here also. That is what they say. Now the government has, in exercise of its delegated powers, done this. If this is wrong, put a challenge to that. Put
No,
that to challenge.
Yes, this is not wrong, Lordship.
This
But
is
the-
correct.
Yes, this is correct.
Then you come to para 9,
Yes. Yes, Lordship.
clause 9.
Yes, Lordship.
Promotion shall remain confined to the so-and-so within the same revenue.
Yes.
So-and-so, 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 so-and-so. It shall be the responsibility of CDPO to determine and advertise them for calling application so-and-so, so-and-so. Then,
Then Lordship, at a time, 20 number of posts get vacant and they advertise for promotion for 17 posts. They did not follow 25, 75.
was your post also advertised, the post wherein you would be eligible to apply, was that advertised?
Yes,
Which was the post?
yes, 69 Shilghagri Lordship. The advertisement Lordship.
69 Silagari.
Shilghagri Lordship. This is
Okay.
page 10, serial number 14.
Hmm.
No, Lordship, no. This is Lordship, page 13, serial number 1.
So in that revenue village wherein Shilghari 69 figures, there are other Anganwadi centers also. So there may be a lady who is eligible. Now you tell me, by filling up this 20 posts, the 25-75 ratio is violated. Just show me that.
Maybe Lordship, I agree, maybe my center may be within the formation, but they cannot Lordship exceed 25%.
And that's what I'm saying. You show me 25% is being exceeded here.
Yes, Lordship, why not Lordship? This is the vacancies Lordship. The vacancies Lordship, page 9 Lordship. This is the vacancy position Lordship. Page 9.
Page 9.
Yes, Lordship. There are 20 vacancies Lordship.
Hmm.
The vacancy arose on 6/6/2022.
Page 9 of which?
My repetition.
Okay, page 9, Annexure 2.
Yes, Lordship.
Okay. Okay, what do you want to submit from this?
Yes, Lordship. There is a 20 number of vacancies. And out of 20 posts, by 2 advertisement, they advertise for 70 for promotion.
17.
Yes,
Now you tell me whether that ICDS project,
yes,
by applying the 17 posts,
yes,
filling up by way of upgradation,
yes.
75-25 ratio was disturbed.
What?
75%, 25% in terms of the ICDS project was disturbed.
Yes, Lordship,
How?
because the existing vacancies, they applied of 75%, 25% is for existing vacancies.
That is in 6-6.
Yes,
Mr. Counsel, you are confusing 6-6 and 11-3. These advertisements are being made in terms of the notification, that is Annexure 2, 4/3/2013.
no, Lordship, that aspect, Lordship, with all respect, that aspect must be clarified, Lordship. What on when the 25%, 75%?
I'll do that.
Yes.
I'll say that it will be in the ICDS center.
Because the commissioner, he's on the affidavit.
Or,
Otherwise,
Mr. Counsel, there can be only 2 yardsticks.
Yes.
One, the Anganwadi center per se.
Yes.
Right? 2, the village, 3, sorry, 2, the village, 3, the ICDS project. Right? Single Anganwadi center cannot be, because it will be only 1 post, no reservation.
Yes, yes.
Right?
Yes.
Village would not be permissible because for appointment to the post of Anganwadi worker, the criteria still
Yes.
is coverage.
Revenue village.
Revenue village coverage. Coverage.
Yes.
Center coverage.
Yes.
So if in a revenue village there are 4, you will be covered only by 1.
Yes.
So again, it boils down to a single post
Yes.
where reservation cannot be applied. Third would be the ICDS project, because in under ICDS projects, there will be a number of posts. So the division would be maintainable. And we will ask them
Yes.
to maintain a
That
list.
point I am lordship coming, they are affidavit lordship, commissioner affidavit lordship.
Hmm.
Lordship, they taken a plea lordship, page 56 lordship, annexure 3.
Hmm. Hmm.
Sir, with reference to the subject cited above, I have no honor to submit here with the information that 400 numbers of Anganwadi centers under.
So 400 posts,
No, yes.
400
numbers
posts.
center districts.
Mr. Council, 400 posts into 25, it is 100.
No, Lordship, but the notification says it is for the existing vacancies.
Show
but
me.
Not the post.
Show me, come to page annexure 2, where it is set for existing vacancies.
Annexure 2, Lordship.
The
But,
central government is just a policy
but
that has been now done. I understand what you're trying to say. You say that the affidavit said that between these two, there is no difference. There can be no difference. But the applicable ratio or the applicable rule or notification would be the state government's notification. It's here. Or show me a rule that this is bad. Present a challenge to this. End of the matter.
then Lordship, the notification annexure 2, it doesn't also say that the ratio should be number of centers.
What would it be otherwise? What would it be otherwise?
Lordship, otherwise, Lordship, in my query, Lordship, some of the decision of this court, Lordship, the Lordship observed that one issue, Lordship. Lordship, one order I am referring, Lordship.
Yes, yes, please. On this issue of Anganwadi worker.
It's under all of our interest, yes. Lordship. In paragraph 6, Lordship.
Well, how does this help you? How does this help you? How will it help you?
Yes, yes, paragraph 6, Lordship.
Okay.
The post of middle Lordship, the post of Anganwadi workers under Director of Social Welfare Department Assam has to be filled up by a proper advertisement and selection following the provisions of Article 14 and 16 of the Constitution of India.
Where is the dispute? That Article 14 and 16 is not being followed. Anything more?
Otherwise, yes, Lordship. One advertisement I like to put.
What is that? Tell me.
Yes, Lordship.
Why
Yes,
this?
Lordship, in that, Lordship, only one Anganwadi worker, Lordship, falls vacant, they gone for direct.
Huh?
The only one post falls vacant, they gone for direct recruitment.
Maybe either you have not understood what I have said or I am not able to appreciate what you're saying. Anyway, we'll hear Mr. Bush. I got your point. Give that advertisement. Advertisement to Lulu. Give it to her.
May, please. My lord,
Just a minute.
the petitioner
ইয়াৰ দ্বাৰা যথাৰ্থে জনোৱা হয় যে কাৰ্যালয় ছুটি কৰি বাছনি কমিটিৰ সিদ্ধান্ত মৰ্মে স্থগিত ৰখা কৰ্মী আৰু সহায়িকা পদৰ Yes. You are appearing for the item number?
Item number 19.
WPC
WPC 6617.
Yes.
Here the petitioner was appointed in 2015, my lord.
You are a Anganwadi helper.
Anganwadi worker.
You are a worker.
Yes, ma'am. And kindly consider one thing, my lord. He was appointed. Kindly come to page 27, annexure 5. This is ordered 6/8/2015. with due
Annexure,
respect-
annexure.
Annexure 5 at
Hmm.
page 27.
Hmm.
With due respect, hereby I beg to inform you that the Anganwadi helper numbers of number 149 Mazgaon Anganwadi Center is being absent from duty since May 2015
Hmm.
till date,
Hmm.
which has been informed by the village people.
Hmm.
Till date, I have also never seen the helper present in the center. In my visit, though verbally she was informed to be present in the center, but still she is absent. It is therefore prayed before you to take appropriate steps. This is the letter issued by Circle Supervisor to the CDPO. Before that, kindly come to annexure 2 at page 20.
Hmm.
My lord, for the Anganwadi Center, my husband donated the land. This is the record, man. And thereafter, I was appointed by the annexure 3, my lord, at page 22. Then, my lord,
Where is the advertisement?
I
Preceding,
continue.
advertisement preceding this 27/2/2015?
My lord, what happened?
There was
my
no
lord?
advertisement.
My lord, they advertised for promotion of the helper. Wherein the next petitioner in the item 20, wherein the next petitioner, she was alleged to work as helper. But kindly consider this petitioner, she challenged the advertisement on the ground that when there is a worker working in the Anganwadi Center, a direct recruitment advertisement should have been given by the respondent authorities.
Okay, got it.
And kindly consider one thing, madam. They have to produce the guidelines saying that where one Anganwadi worker is working, whether they will follow the promotional basis or direct recruitment.
That
And
is already clarified by Mr.
my lord, in the ICDPS center, 75 and 25% has been done and or not. that has to be established by either producing record
No.
or by,
You allege, you make an allegation that 2575 has been violated. There is no allegation. No allegation. No allegation, Mr. Busho. If you can find out, I might have missed out, you find out.
my lord, I'll check. To date, my lord. My lord, only consideration is, my lord, when there is already one Anganwadi worker is working temporarily. In that event, what they will do?
And you have in paragraph 13,
Yes.
you have said that this is 100, amounts to 100%. Anganwadi center is not the base, is not the cadre. Cadre is all Anganwadi helpers or Anganwadi workers under an ICDS project, 75-25. Because you people have not, none of you have challenged that 75 cannot be given or 25 cannot be given. So you can't take the unit as a single Anganwadi center. It has to be the entire ICDS project. So that goes. Anything more, Mr. Vishwa? And you have not even challenged the latest guideline, 11.3.
Madam.
Okay. This is Bhavanipur.
Bhavanipur. We have challenged the advertisement and there is a factual dispute, madam. Whether the repetitioner in this case is working as worker or the helper is. also-
Anyway, either as a worker or a helper,
Listen, madam.
you are not through a direct recruitment, you are on ad hoc basis. And Mr. Sigda, what is your case? Your for item number?
My lord, same Mazgaon ICDS center. Lord, I was appointed as an helper in the
Atta
year
thank you,
2007.
Ruta hai sikh.
My case is, my lord, 7314.
7314. Yes, you are.
My lord, I was appointed in the year 2007
Hmm.
as an Anganwadi helper. Annexure 1 page 15 is my appointment letter.
After advertisement, selection and all.
My lord, they have appointed me and I am working, my lord.
Hmm.
And the existing, my lord, worker, Anganwadi worker died in the year 2014.
Hmm.
And the Anganwadi worker post is lying vacant since then, my lord.
Hmm.
And I was working as an Anganwadi helper. Also, I have to discharge duty as an Anganwadi worker also.
Hmm.
My lord, my friend in the earlier case, my lord, claiming that she was appointed
Hmm.
as an Anganwadi worker.
Hmm.
He was appointed only for 90 days. And thereafter the post is vacant.
So
and
you want, in this case, you want that 4/3/2013
Yes, my
has to be taken into account. Your post was also advertised by
lord.
7/11,
Advertised, my lord. That is there, my lord.
17/11/2011.
Yes, my lord. There is an advertisement. I have
Page, annexure 10.
Annexure 10, my lord. Annexure 10, my lord, there are as many as 8 posts of Anganwadi worker post.
So
that
you
is
are
under the
interested in
ICDS.
Mazgaon.
Yes, I am Mazgaon, 149 Mazgaon South. And
So
my
you
lord,
want this advertisement to be taken to its logical
my
conclusion.
lord, I have also applied. That my consideration, my case will be considered, and the advertisement was made only fill up by upgradation. That is their challenge. As per the director's letter dated so-and-so, some of the posts of Anganwadi workers are lying vacant in Bhavanipur ICDS project under Social Welfare Development. Applications are invited from Anganwadi helpers residing in the revenue village willing to render voluntary services for Anganwadi worker in the vacant post of Anganwadi workers. Interested candidates can apply along with the required documents under the following terms and conditions. 2 copies of passport size photographs shall be affixed. My lord, this pursuant to this advertisement, I applied other from other center also applied. All the
Mr.
other
Sikdar, if we hold
Madam.
that the advertisements in absence to a challenge to the policy is not challengeable, finish, that is the end of the matter.
We are not challenging the policy comment.
How
Government
can you, why
policy,
should you, if they have not challenged,
my lord.
you have not heard my discussion, my interaction with Mr. Majumdar and Mr. Vaishyo. We can,
My lord, I feel that if my case is considered in the guideline of the government, I may be considered that.
but
And I
for
have
that we
also
will have to
applied-
reject their cases first.
My lord,
Ah,
that is
yes,
up to your lordship.
Well, only one additional information, I'd like to apprise the lordship. But in the meantime, there is a decision at the government level, that 6327 Anganwadi centers, they will be merged with some amalgamation processes there. 6327 Anganwadi center throughout the state.
Hmm.
So some Anganwadi centers are merged with the one Anganwadi center. Well, I don't know whether this center falls in that or
So
not.
we'll make an observation
Yes.
if provided the center is operational along with the post there.
Lot.
Right.
Otherwise, in the amalgamated thing, no further appointment can be given. If it is in the merged or it is outside the limit, then definitely they will.
Okay, dispose of.
Right. Bibliography.
We'll only record what you have said.
If it
We'll
is
record test it, it's not that, but the
lot,
policy that you have brought on record,
lot.
we'll say, and we will direct the CDPO to maintain a list of appointees under by upgradation and appointees through direct recruitment
Yes.
against the post of
Yes.
Anganwadi worker
Yes.
at the CDPO. We'll say
Malad.
that this has to be done 75-25 under the ICDS project,
Lot.
and he will maintain a list
Lot.
so that 25 and 75 is not disturbed.
Yes. Lot.
Sorry,
But-
Mr.
If Malad, the instruction is there, I'm just indicating, Malad, if suppose 4 Anganwadi centers are there in a revenue village, but the helpers are not eligible, then
Then it will go for direct
then it
recruitment.
will go to direct.
That
Yes.
CDPO will make that.
It is already there. So
And
while
anybody,
assessing-
I'll say that assessment that is made, if it is wrong, anybody can come up and challenge that assessment.
They are likely to withdraw the affidavit filed by the director lordship. In the commissioner's affidavit, they said that they would like to withdraw the affidavit filed by the director lordship. That observation may be made, lordship. What inconsistency between.
Malad,
these two
since
affidavits.
the government has clarified the stand, I'm not pressing that. That is one thing. Because the stand is clear from the
When the
government.
father says that this is this, what is the grandson going to do? What the grandson or son says, it's of no use.
Consistency, lordship, what they have said, the affidavit in the director filed by the affidavit.
Affidavit, director's affidavit is wrong. We'll see.
I'm obliged.
We'll consider your judgment also, Mr. Sama. Majumdar, don't do. M2. Yes, Mr. Chaudhary.
In the morning, I had to be in court number 2 for item 1.
May I please, Your Honor? Not matter pertains to anti-tax lordship. Not in clear, not challenge orders passed by the Commissioner of Tax, not under section 105 of the Assam Value-Added Tax Act.
You said that this matter is covered by some decision, this decision.
Not, yes, lordship.
How?
The interpretations, lordship, the interpretation of the entries, my lord.
Hmm.
Not, on the last occasion.
Okay, show me the entries first.
My lord. What is the entry?
Value. You have not filed an affidavit here.
They have filed.
They have
It was
filed.
filed. It was filed.
Oh, yes, you have filed.
Yes. So you know,
Assam Value Tax.
Assam Anti-Tax Act.
And Anti-Tax Act.
2008.
এটা দিয়া নাই নেকি তাহলে? You have an extra copy? দিব যে, দিব। পাইছে, পাইছে, পাইছে। Yes.
My lord, schedule, my lord, attached to
Hmm.
the act, my lord. The 11 entries are entry 3 and entry 4, my lord.
Entry 3 and entry 4.
First, your lordship may see entry 3, my lord. That is telecommunication equipment, including telephones, mobile phones, pages, and components and parts thereof. Thereafter, entry 4, my lord. This is television sets, both colored in black and white, video cassette recorder, video cassette players, DVD player, VCD player, DVD player, video cassette tapes, wireless reception instrument and apparatus, and radios and parts thereof. My lord, the petitioner, my lord,
This is a very wide,
my lord, when my lord,
wireless reception instrument would mean
my lord, television sets and radios are otherwise also included, my lord, within the meaning of, my lord, wireless reception instrument. My lord, when, my lord, there are specific entries, my lord, when there are group of entries which is similar to each other, and there are general entry, my lord, which is wider in sense,
it has to be read in connotation.
my lord. That was the, my lord, observation of the, my lord, the interpretation provided by Honorable Supreme Court, my lord, which judgments we are going to rely on, your lord. So, my lord, there are two orders. First, my lord, the clarificatory order, my lord, which your lordship will find at lordship page 46, my lord. My lord, page 34, my lord, annexure 2 of the writ petition. Page 34, my lord, annexure 2.
Yes.
So and so has filed an application under section 105 of the Assam Valuated Tax Act, Rule 9 of the so and so, seeking clarification as to whether entry tax is leviable on equipments, goods used for so and so.
This is sort of an advance ruling. Sort of an advance
My
ruling.
lord, under the
Hmm.
act, my lord, power has been conferred with the Commissioner of Taxes, my lord. My
To
lord,
give this clarifications.
Lordship.
Hmm.
Lordship. So accordingly, my lord, we applied, my lord, and this clarification has been, my lord, issued, my lord. Paragraph 2, my lord, Sri so and so practicing appeared for on behalf of the petitioner and filed his submissions. He submitted that the items goods mean for telecommunication as occurring in entry 3 of the schedule of the Assam Entry Tax Act 2008 does not hold good in case of so and so. The publicity media and the said item goods cannot be linked or submitted connected with the operations of the said broadcasting media in its day-to-day functioning. He submitted that applicants is in the business of broadcasting. Major part of the technology used in the broadcasting is similar to that used in telecommunications, but the same is not used in entirely. Thus, the principle of end use of the technology must be accepted while applying the principles of taxes on it. He also submitted that government has exempted Prasar Bharati and Doordarshan from payment of entry tax on the goods specified in the schedule which are meant for own consumption and exclusive use of Prasar Bharati and Doordarshan. Peruse the submissions and the entries of the Assam Entry Tax Act schedule has been examined. As per entry at serial number 3, telecommunication equipment including telephone, mobile phones, pages and components parts thereof are taxable at the rate 4%. Further, as per entry serial number 4, wireless reception instrument and apparatus and radios and parts thereof are also taxable at 4%. The petitioner himself has admitted that the goods mentioned by him, that is major part of the technology used in broadcasting, is similar to that used in telecommunication, but according to him, as end use is different, therefore same cannot be brought under the telecommunication equipment. In fact, while imposing tax and same cannot be decided on the basis of end use. If an item is mentioned in the schedule whereby tax is leviable on such item cannot be said to be exempted by judging the use of the item. Tax shall be leviable as per entry in the schedule. Therefore, the items mentioned by the petitioner shall come under the purview of the Assam Entry Tax Act 2003. Lord, therefore, my lord, the commissioner hold that it comes within the purview of my lord entry 3, my lord, as my lord accepted by the my lord petitioner not themselves. That was the observation. Thereafter, my lord, we filed a my lord review petition, my lord. We are submitting two decisions, my lord, of this Honorable High Court, one, my lord, by the division bench, my lord. The which, my lord, says, my lord, when the my lord, what including is there, my lord, in the my lord entries in the schedule, my lord, which my lord restrict the meaning of a particular entry, my lord, the particular words, my lord. My lord, in that case, as my lord, the relevant, my lord, question was whether, my lord, the films of all kind, including X-ray films, whether that can include the, my lord, other polyester films, my lord, for the purpose of levy of entry tax. The Honorable Division Bench has said, my lord, no. When the meaning of, my lord, the word including is mentioned therein, which refer to a, my lord, only X-ray film, my lord. So therefore, the meaning of the, my lord, all kind of, my lord, the plus films, my lord, that has to be read, my lord, in respect of the nature of the, my lord, X-ray films only, my lord. And the other judgment, my lord, which, my lord, relates to, my lord, the lordship, the sound, lordship, my lord, I'll place the judgments, lordship.
Okay, you can take me through to the thing. They said that simple.
My lord, yes, my lord. After we filed a review application, my lord, we are placing both the judgments of this Honorable Court. Thereafter, my lord, the review order was passed at page 46, my lord. That is Annexure 4, my lord.
Same authority.
Same authority. Page 46.
And here the High Court judgments were also
My lord.
noticed, but somehow it was not taken up. That is your case.
No, my lord, it was considered, my lord. What my lord, Learned Commissioner has did, my lord. Learned Commissioner is satisfied that the items does not fall under entry 3, my lord, as has been, my lord,
held by him earlier.
My lord.
He says now it will be 4.
Exactly, lord. Now he has said, my lord, since it is not covered under entry 3, now it will fall under entry 4, my lord.
What is the exact good?
My lord, the goods are, lordship, C band, KU band, my lord, your lordship will find that para 5 of my repetition, my lord. These are the items, my lord, used for the purpose of uplinking and downlinking of signals, my lord. That is used for, my lord, in the telecommunication sector, my lord. Page 7 of my repetition, para 5. It is C band. We have mentioned the description of the goods, my lord. It is in respect of, my lord, when, my lord, it is used by OBB van, my lord, for collecting news, my lord, at the field.
So is it your case? Is it your case that, what is your case exactly? That this equipments will come under entry 3?
No, my lord. Our case
Your
is, my
case
lord,
is it neither entry in 3 nor 4?
nor in entry 4, my lord, and
it has not been specified. It has not been specified in the entries. You cannot levy a tax. Is that your case?
Lord. And in fact, my lord, by the
You mean to say C band,
yes,
KU band, satellite receiver,
yes,
so and so modem, top box, encoder,
yes, Ecoder,
cannot be considered because that is not.
Fall within
So
either in
wireless reception instrument and apparatus
my lord.
is something which is a television or like, which is given there.
Radios and other parts, my lord. What we are submitting, lordship, the entries, my lord, entry 4, my lord, that has, my lord, otherwise also, my lord, the radios and, my lord, television, that falls, my lord, within the meaning of, my lord, the wireless reception instrument, my lord. When the legislature, my lord, used a particular word, my lord, the
Television sets, when this act was enacted,
my lord,
maybe a little bit before also, television sets were on antennas. They were not wireless.
my lord, in fact, antennas, my lord, it is wireless in the sense, my lord, it receives
Now,
signals.
nowadays it can be wireless.
In fact, my lord, earlier days also, my lord, it is through antennas, but that is, my lord, receive signals, my lord, from the, my lord,
Okay.
television station.
Then what is the judgments of this court? This
Yes,
is the
my lord.
case.
I like to place, my lord, 2 judgments of the Honorable Apex Court, my lord.
Which is the first one?
Not, this is 1997, 8 SEC, 511.
Yes, I have a copy.
Mile.
Para 9.
Lord, this is Paradip Agarbatti. My lord, in this case, lordship, your lordship will see the entries first in paragraph 3, my lord. The entry 16 of the schedule A to the act at the relevant type read thus: cosmetics, perfumery, and toilet goods, excluding toothpaste, tooth powder, kumkum, and soap. So, my lord, your lordship will see the relevant observation at para 9, my lord, page 514, my lord. Entries in the schedule of sales tax and excise statute leaves some articles separately and some articles are grouped together. Then when they are grouped together, each word in the entry draws color from the other words therein. This is the principle of nocitur socius. We are in no doubt whatever that the word perfumery in the said entry 16 draws color from the word cosmetics and toilet goods therein, and that so read the word perfumery in the said entry 6 can only refer to such article of perfumery as are used as cosmetics and toilet goods are upon the person. The word perfumery in the context in which it is used has therefore no application to dhoop and agarbatti. The distinction between the present case and in the case of so and so is evident from the word perfumes in the entry under consideration in the later case was not limited by the words before and after. As in the entry before us, both the words scent and perfumes related to articles that produce fragrances. Consequences, we are of the view that the judgment under appeal is erroneous and must be fixed. So, my lord, honorable apex court has held, my lord.
That it has to take color
My lord.
only from the
My lord.
words used.
My lord. Because
Now, or the description given.
My
So
lord.
Chettiar, one thing you just clarify from 9.
My lord.
If we have television, we have radio, we have here, and we have wireless apparatuses.
Yes.
So by applying this 9 and 10,
My lord.
applying 9 and 10,
My lord.
so anything connected with television
My
or radio
My lord.
would be a wireless apparatus.
My lord.
So these things are connected with radio and television.
My lord. My lord, because
C-band.
these exactly, my lord. These goods, my lord, which the petitioner, my lord, imported from outside the state. Those items, sir, my lord, does not produce any sound transmitting equipment.
Need not be. Perfumery, here the words are,
My lord, in this
if you
case,
see the
my lord,
words,
yes, my lord. The perfumery otherwise includes, my lord, dhoop and agarbatti, my lord. That also, my lord, my lord, it remits, my lord, the perfumes, my lord.
perfumery, including dhoop and agarbatti is the subsequent one.
My
This court was considering cosmetics, perfumery, and toilet goods. So it limited the word perfumery
My lord.
in the context of
Yes, my lord.
cosmetics and toilet goods.
My lord. Lordship.
So anything that is used
My lord.
for the purpose of cosmetics
My lord.
and for the purpose of toilet goods,
Lord.
if you import that, you have to
Those
give
can be only considered as, my lord,
entry tax
included
under
in
that
the, my lord,
entry, under that entry.
My lord.
But it will not go and hold dhoop and agarbatti because it was not related there,
My lord.
right?
My lord.
Now here, it's TV and radio.
My lord.
Both are wireless.
My
So
lord.
anything connected to that,
My
or for the TV cannot run without programs. Can a TV run without program?
My lord, what I
Can
am
a TV run without a program?
No, my lord.
Then
Because it is meant only for the purpose of, my lord, viewing programs, my lord.
I know that.
My lord.
To view that program,
My lord.
sorry, I may be wrong, but correct me.
Not,
To view that
my
program,
lord.
you will have to send a program.
My lord.
And wireless and other apparatus are used for that purpose.
My lord.
Then next judgment.
My lord, the next judgment is lordship, that is 2000
Godrej Philips.
2005, my lord.
2 SSC 515.
My lord.
Mm.
My lord, here, my lord, the Honorable Apex Court has, my lord, struck down the various act, my lord,
Hmm.
which levy, my lord, luxury tax on goods, my lord, that is on, my lord, tobacco products.
Hmm.
But here, my lord, the constitutional entry was, my lord, your lordship will.
Entry 62.
Yes, my lord, your lordship will find that, my lord, page 524, my lord, para 2 itself, my lord. Entry 62 of Leagues 2 of 7th schedule to the Constitution relates to exclusive power of the state legislature to make laws with respect to taxes on luxuries, including taxes on entertainment, amusement, betting, and gambling. That was the entry, my lord. Thereafter, my lord, various, my lord, states government, my lord, state legislature has, my lord, enacted, my lord, luxury tax, my lord, upon certain goods, my lord. So then, my lord, the Honorable Supreme Court has, my lord, then, my lord, relevant portion, my lord, para 75 onwards, my lord. Your lordship will see
70.
para 75, page 549.
Hmm.
Where two or more words,
Used in the cognate sense.
my lord, para 75, your lordship, that where two or more words susceptible of analogous meanings are clubbed together, they are understood to be used in their cogent sense. They takes, as it were, their colors from and qualified by each other. The meaning of the general word being restricted to the sense analogous to that of the less general. Thereafter, my lord, see para 77. In the present context, the general meaning of luxury has been explained or clarified and must be understood in a sense analogous to that of the less general words such as entertainments, amusement, gambling, and betting, which are clubbed with it. These principles of interpretation known as nocite res sociis has received approval in Rainbow Steels Limited so and so, although doubtful in its indiscriminate application in so and so. In the later case, this court was required to construe section 2 of the Industrial Dispute Act, which reads so and so. Thereafter, my lord, see para 79, my lord, page 550. We do not read these passages as excluding the application of the principle of nocite res sociis to the present case, since it has been amply demonstrated with entrance of authority that the meaning of the word luxury in entry 62 is doubtful and has been defined to the. So, my lord, Supreme Court says, my lord, this doubt raised that was not proper. No, thereafter para 81, my lord. Aware that the maximum of nocite res sociis may be a trichorus one unless the societies to which the soci belong are known. The risks may be present when there is no other factor except contiguity to suggest that societas. But where there is, as here, a term of wide denotion which is not free from ambiguity, the addition of the word such as including is sufficiently indicative of the societas. As we have said, the word includes in the present context indicates a commodity or shared features of attributes of the including word with the included. My lord, para 83, my lord, you'll also fine. Hence, on an application of general principle of interpretation, we would hold that the word luxuries in entry 62 of list 2 means the activity of enjoyment of or indulgence in that which is costly or which is generally recognized as being beyond the necessary requirement of an average member of the society and not articles on luxury. My lord, otherwise, my lord, the word used there in a luxury, but it specifically says that, says, my lord, taxes on luxuries, including taxes on entertainment, amusement, betting, and gambling. So, my lord, the luxury, my lord, it takes color and its application is limited to the entertainment, amendment, betting, and gambling, my lord. Considering this, my lord, all the acts have been, my lord, struck down, my lord, being, my lord, ultra vires to the constitution. My lord, what I am submitting, my lord, this entry in the present case, lordship, the entry, my lord, entry in the schedule, my lord, that is very specific and clear, my lord. All the entries, my lord, except this wider entry, wireless reception instrument and apparatus thereof. All the entries is, my lord, the items, my lord, which either, my lord, it can be viewed or it can be, my lord, hard, my lord. It can be which, my lord, which is, my lord, final product in itself, my lord. It is used by the viewers only, my lord. and
So
it is
what
the-
would be the meaning assigned to these words? Wireless reception instrument and apparatus?
My lord, anything.
There
which
has
is-
to be some meaning attached to that.
Yes, my lord, we can
What
say,
would
my
it
lord,
be?
and with this, my lord.
Because
items,
in
my
the
lord,
Supreme Court, both the decisions, Supreme Court has assigned a meaning
my lord,
to the term.
my lord.
What was the meaning here?
My lord, it includes the other items, my lord, which is, my lord, similar to televisions.
What is that similar to
My
television?
lord, that may be something like Bluetooth speaker, my lord. That
It
is also
cannot
not
be.
there.
It will have to be put in there.
My lord, because, my lord, that
Because
is,
again, that is not defined. It's a product in itself.
my lord, with, my lord, if we consider it, my lord, along with these other items. Because, my lord, all these items, my lord, that is a finished product. And that is used by the viewers or listeners, my lord, that directly, my lord. It was not used by any intermittent agencies, my lord, for uplinking or downlinking of signals, my lord. My lord, television sets, my lord, it is not imported by any other person except the viewers, my lord. They are the, my lord, the final, my lord, viewers, my lord. It is the final product. All items, my lord. My lord, whatever items we imported into the state of Assam, my lord, that is not used by the viewers, or
As-
it is the not final
Has
product.
this entry tax during the validity thereof undergone any amendments? After 2008, it has not undergone any amendment.
My lord, some minor changes, new entries has been incorporated, my lord.
In 4.
My lord. My lord, new entries have been incorporated, my lord, many entries, my lord, after incorporation of the act in 2008. In fact, my lord, the first anti-tax acts were enacted in 2001, my lord, Assam Anti-Tax Act 2001. And that was, my lord, struck down by this honorable court, my lord. It was challenged before Supreme Court, my lord. And during pendency of the act, my lord, the new act came up, my lord. This is Assam Anti-Tax Act 2008, which also validate, my lord, the levy of, my lord, taxes which was collected, my lord, that under the earlier act, my lord, that was validated, my lord, under this act, my lord, itself. 2008 act, my lord, that is section, my lord,
13,
lordship there.
12 and 13.
Lordship. So this act, my lord, also validated the earlier act also, my lord, the levy, the collection and levy of.
So
the-
this is your case, it's not covered, so you cannot have an entry tax on that. That's all.
My lord, because, my lord, with these judgments, my lord, when, my lord, the apex court has specifically said, my lord, when there is a, my lord, general entry, and there are other entries, my lord,
So that
similar,
other entry must be read in the color of the general entry.
my lord, the general entry must get the color of the, my lord, other specific entry.
Specific.
So that is my humble submission, lordship. So this is-
Yes.
Lordship, here, Lordship, may kindly take up our affidavit. Paragraph 4. Internal page 4. Lordship, I'm reading it, that with regard to the statement made in paragraph 6 of the writ petition, the answering respondent states that the entry wireless instrument and apparatus.
You are
covered
reading?
the entire
You are reading?
paragraph 4. Affidavit filed on 12/9/2014.
Oh, sorry. Yes.
That with regard to the statement made in paragraph 6 of the writ petition, the answering respondent states that the entry wireless instrument and apparatus covered the entire class of apparatus which uses wireless technology. The petitioner has submitted the specificity of the function of the item imported from outside the state, as the petitioner contention is to gain exemption for the above item. The petitioner submitted that the items in question are used for uplinking and downlinking signals for the purpose of broadcasting. On meticulous examination of the nature of goods, it is observed that the service and function of the goods imported by the petitioner are in conformity with the item wireless instrument and apparatus under entry 4 of Assam Entry Tax Act, and therefore the contention of the petitioner is incorrect and therefore not admitted. Lordship, now Lordship may turn to paragraph 13. That with regard to the statement made in paragraph 18 and 19, read petition, the answering respondent states that the order was passed as per provision of law and also in conformity with the law, stating that the items fall in entry 4 of the Assam Entry Tax Act 2008. The answering respondent further states that the items in disputes, except set-top box and encoder, are used exclusively for transmitting signals. The contention of the petitioner in this paragraph are ambiguous and contradictory. He has himself admitted that the items in question are mainly used for satellite communication for broadcasting services, and such services are transmitted for uplinking and downlinking signals. So it is clear that the apparatus are used apparently for transmission and receipt of signal, the uses of which it brings within the parameters of entry 4 of Assam Entry Tax Act 2008. So these function of apparatus were taken into consideration at the time of clarifying the items in question. The function and services of the goods dealt by the petitioner are in conformity with the entry 4 of the Assam Entry Tax Act. So on judicious review of the matter, a review clarification was made accordingly by the order dated 24/9/2013 and duly communicated to the petitioner. Lordship, here Lordship has seen the entry wherein it states that wireless reception equipment, reception instruments and apparatus, and radios and parts thereof. Lordship, the function of the petitioner with those equipments are to send signal, and it cannot be received by the end user with wires or anything. It has to be wireless reception. Lordship, and while the wireless reception is required, or they while transmit it, it is also wireless reception instrument. Any wire or any other thing else that connects to the end user. Lordship, that's why it is a vast area. So that includes the broadcasting equipment also for the purpose of broadcasting. And Lordship, after going through the judgment, I found only one in it defines the apparatus in connection with satellite decoder. Lordship. Right. Two 2007, 12 SCC, 72. Paragraph 36, Lordship. Here it states that is equipment that are necessary for transmission. That means apparatus.
Para 32.
36. Okay.
So this is at the end user.
Yes, Lordship.
And what Mr. Chetia is saying is the starting point.
Starting point, Lordship. But because their purpose of the Lordship will have to take into account the purpose of the equipment, because it has to go to the end user.
Is the entries given here somewhere?
Yes, Lordship, at the beginning, Lordship, it was in connection with the Customs Act. 825A. Lordship, it has been quoted also.
But that was a very specific entry.
Yes, yes. Specific with regard to the television receiver.
Okay, anything more?
My submission is that it's an use, it's a general term. It includes everything and taking into account the function of the petitioner for those equipment. It comes within the wireless reception entry. And secondly, Lordship, this act is also under challenge and it's still pending
Where?
before this court, Lordship.
Whole act.
Whole act, Lordship.
So what would be the effect of that here? We'll decide this. Subject
Particularly
to
here, my lord, we are challenging the levy. And my
actually
lord,
levy, that
Yes.
is the whole entry
Yes, my lord.
act here.
My lord.
That will have no rules.
In fact, my lord, my friend has rightly said, my lord, that entries, my lord, the, my lord, wireless reception instruments, my lord, it's a very wide entry and it includes everything. In fact, my lord, radios and television sets are also included in this, my lord, wireless reception instrument. In fact, when, my lord, this,
No, what was the intention of the legislature in incorporating those three words?
exactly, my lord.
Hmm.
Intention is, my lord, only
We'll have to give it a meaning.
to levy taxes on those items which are finished products and which are used by the viewers or listeners, my lord. Not to levy a tax, my lord, to those items, my lord, which is required for other purposes, my lord, for uplinking or downlinking of signals, my lord. Because all these items, my lord, that is restricted, my lord, to the, my lord, instruments, my lord, which are used only by the, my lord, the end user, my lord. Television sets, both colored and black and white. In fact, my lord, it was also clarified. It is applicable to both.
Because you see,
My lord. My lord, everything. Video cassette recorder, video cassette
you
player,
come to entry three,
entry three.
telecommunication equipment, including telephones, mobile,
My
pagers.
lord, the respondent number 2, my lord, the Commissioner of Taxes has already opined that it will not fall under entry 3.
I'm not on that.
My
I'm just trying to understand that entry.
Sorry.
Telecommunication equipment, including telephones, mobile phone, pagers, components, and part thereof. It is a wide thing. So, if you are importing something with regard to your, say, a tower,
Right.
in the tower there is that transmitter.
Right.
That will come within telecommunication equipment.
No, my lord. Because, my lord, when the, my lord, entry, my lord, telecommunication equipment, that is,
Including.
my lord, what I am submitting, even, my lord, without considering the other components, my lord, including telephone, mobile phone, etc., my lord, telecommunication equipment is sufficient to include, my lord, telephones, mobile phones, pagers, and the other parts thereof.
Then why was it?
Yes, my lord. When it was, my lord, specifically included, my lord, within the definition of telecommunication equipment, it restricts the meaning of telecommunication equipment and it has to be,
this.
it has to be, my lord, related only with respect of telephone, mobile phone, pagers, and components and part thereof. My lord, I will like to place, my lord, 2 judgments of this honorable court, my lord.
Please do so.
My lord.
Color from the other entries.
My lord.
Can it only be mean that the color would be with regard to the use of those use of those other items or for use of those other items? say television. Giving an example, it can be a laptop also. So whether the television entry parameteria would mean a laptop or something to make that television work, that will also come within that entry. That is permissible.
Lordship, if Lordship takes into account the laptop also nowadays, wherein the one can view everything, there is also some component for receiving wireless signals or data, everything, Lordship. Those will come the wireless reception, to my humble understanding, Lordship.
Yes, sir, that will come, my lord, because it is a final product and it is utilized by the, my lord, the final, my lord, users, my lord. It is similar to televisions, radios, my lord, because it transmits sounds and it transmits, my lord, videos, my lord.
And in television also, those signals are, let's say, encrypted, and to decode it, there has to be something in those television.
My lord, I'd like to draw your attention for, my lord's attention for, my lord, this 2008 1 GLR 380, that is Starlight Optical Technologies Limited, my lord.
That has interpreted entry 3.
In the first order, my lord.
Hmm.
My lord, and it was it was accepted, my lord. They said when, my lord, the word word mentioned there in including, my lord, that including restrict the general entry.
Here that is not there in entry number 4.
Here, my lord,
It is also wireless reception in
My lord.
instrument and apparatus that has a definite connotation.
my lord,
It is not perfume per se.
my lord, otherwise, my lord, perfume, my lord,
It
includes,
can be,
My
Mr.
lord.
Just trying to.
my lord,
Wireless reception instrument and apparatus, perfume.
my lord,
So perfume in the context of toilet goods and
lord, the cosmetics.
cosmetics. Now, perfume here would mean that the thing which goes into cosmetics and toilets, right? That is that perfume. So dhoop and agarbatti is not there,
Yes,
right?
lord,
So here perfume per se
is my
has
lord,
got no use.
Hello.
It is perfume that is used in toilet
Right.
goods and cosmetics. Similarly,
Right.
here wireless reception instrument and apparatus
my lord,
would not be something which is not used
Right.
for the purpose of operating a television till a radio.
my lord,
It is something
Right.
which is connected to that. It
Lord.
cannot mean any wireless.
my lord, my
Like here, the optical fibers
Lord.
was said that it's beyond.
Right.
Because that is not tuned with the
lord. Lord, what? My lord, I am asking a question to myself, lord. My lord, sound transmitting equipment. That is sufficient to include television sets as well as radios, my lord. My lord, and other equipments, my lord, which was mentioned. My lord, why this legislature has specifically mentioned, my lord?
now the
television-
set-top box was excluded in by some other notification.
My lord, my lord, respondent number 2 has hold that since it is not specifically mentioned in the schedule, my lord.
No. It says that set-top box and something else is already exempted. That is the word. Subject to correction.
As set-top box and encoder is not mentioned in any entry under the state schedule. The last 3 lines, lordship, page 46. As set-top box and encoder is not mentioned in any entry under the state schedule, no entry tax is payable on such items.
The items except set-top box and encoder mentioned above are wireless reception instrument and apparatus used for broadcasting for television. As such, it is clarified that items mentioned shall be covered under the entry so-and-so attached to the so-and-so. As set-top box and encoder is not mentioned in any entry under the schedule, no entry tax is payable on such items. Further, wireless modem shall also be taxable under entry
So, my lord, all other items are also not there, my lord. No specific entry in the schedule, my lord.
So, Mr. Chaudhary,
Yes, ma'am.
because set-top box and encoder is not mentioned, huh?
Yes.
You have taken it out of the purview, but that is also a part of a wireless equipment. It would come within the meaning of wireless reception instrument and apparatus. Now, if these two have been taken out, how can you bring in C-band satellite receiver, etc., which is also not specified? KU band. It is like the optical fiber in entry 3. Because this satellite receiver, KU band, antenna, these will have the effect of carrying the signals. Similar to the optical fiber, a cable and accessories in that Sterlite Optical Technologies
Yes.
case. So if that is held to be exempted, out, not covered, how can these items be read into this? Mr. Chettiar, to that extent is correct.
Yes, my lord. That I have to clear because the nature and work of the set-top box angle is under wireless loss.
Wireless and apparatus.
Yes, Lord.
So you yourself having said,
There
we
must
can
be-
draw a deduction from here, specific mention not being made, it will be out. So if that be so, specific mention of similar nature, how can you bring it? And you read this, he has also considered 2008 1 GLR. Therein also, the dispute was sound transmitting equipment.
Lordship,
So whether it will also include an optical fiber, cable, accessories, etc., it said nothing doing, it won't.
Lordship, I'll try to get it clarified, this set-top box and encounter, encoder.
I want the wordings here. Set-top box and encoder is not mentioned, so it cannot be brought in. If that be so, CU band, KU band,
Then
satellite,
automatically everything
everything.
goes. Because going by the clarification given, Lordship,
Mm-hmm.
it's they taken into consideration the function of each.
Each account. So that function, it's not set-top box function not being held to be same as that of a TV or a radio.
I'll try to get it clarified.
Sorry, it takes time because
Yes.
these matters I'm trying to understand.
Yes, ma'am.
Here did you? When? Tuesday?
Tuesday.
Lord, I'll be out of station, Lord.
When?
Lordship on 28th, Lordship.
I won't be here from 19th.
Any date, Lordship,
When are you coming back?
My lord, next Tuesday, my lord, I have a matter in outlying bench, Lordship. But then
When are you
thereafter,
coming back?
In the next week also, my lord, I have some matters, my lord.
When Tuesday you go, when are you coming back? Tuesday?
My lord, Thursday only, my lord.
Then we'll have it on Friday.
Lordship, can it be on, my lord?
Or it will have to go to
On
3rd,
16th, my lord, on 16th, Friday.
16th Friday.
Lordship,
Only a small point.
Lordship, yes.
16th. Third deal on council for the parties. Hearing remains inconclusive. Accordingly, registered to list this matter again on 16/8, 2024 for further hearing. File to matter 24. Thank you. Interesting.
Lordship. So it's a basically interpretation, Lordship.
And don't mind me asking questions in
Lordship.
that one. I'm trying to understand, that's all.
In fact, my lord, I am also, my lord, trying to understand the meaning assigned to, my lord, all the words.
So perfume, this we are trying to connect.
Otherwise, my lord, also, my lord, dhoop is included in the
Perfume, perfumery,
Lordship.
world
Perfume,
perfumery.
exactly. So these are the
21 to 23.
You are not filing any written statement? A written argument are you filing? No. Mr. Gupta has already filed. Then we will reserve it.
Today I have prepared chart, my lord. It will clarify.
We are only seeing whether the allegation is of such a nature that it can be brought to his shoulder that he has committed some pilferage. Just by way of
Yes, my lord.
shortage.
Specifically, we have mentioned that during his tenure, uh, the date of formation of the stack was formed in. Your
No, no, he has given specific data on that. The stacks that he had
From
formed.
his document only, I will place it.
Huh?
From his document only, I will place it. I have the this. First of all, my lord, Ranjit Singh case.
Hmm.
My
Where
lord,
is
this-
Ranjit Singh? Okay, this
My
one.
lord, this chart, my lord, kindly
Hmm.
take it out. One, he was there from 12/7/2017 to 31/12/2017. Zero PV start date is 25/8/2017 and it was ended on 14/9/2017. Zero PV, my lord, all the everything will be the bag wise, weight wise. So it was.
So
It
this
was
shed
found.
number one, this loss is already been 6,000 odd. It has already been recovered from somebody else.
No, my lord,
Yes, Mr. Gupta.
there were, my lord, there were, my lord, 11 officers, my lord,
I know
including
that.
these three.
I know that. Shed number one, 6,000 that you
6,000.
assigned to him is already assigned to somebody else.
Yes, Gopal Chandra, that
Ah,
was
then
recovered.
why, that is gone.
It was.
Now, site number one, only 1 quintal was, there was a loss, my lord, unjustified loss, my lord.
6,000
Site number
rupees.
three, there was a storage loss of in quintal 568, my lord.
Okay.
Out of which
Now,
unjustified. Yes, my lord.
His period is from 1/7/2017. Right?
Yes, zero.
No, shed number three, 1/7/2017.
Hmm.
Right? Right?
Yes, sir.
To 31/12/2017. Right?
22/9/17.
Now, we have counted for 17/2017 to 22/9/2017.
22/9. It will be
22/9.
22/9.
22/9/2017, my lord. So during his tenure, my lord.
Okay. 2 months.
2 months, my
2
lord.
months.
2 months.
Literally 2 months.
2 months. So
Now, you have this zero PV on
madam.
22/9/2017.
Yes, it started from 25/8/2017.
Now,
It was
within
completed
this
20
2 months, the storage loss, it's not pilferage, material is there. But because of certain activities of not keeping it properly, rodent, moisture, 568 quintals is lost. Is it humanly possible?
Yes,
That one man within 2 months, that means you have a inbuilt defect in the whole system, that means.
No, my lord, to the point, my lord. During, we are we are keeping apart the stack which was not made during his tenure, my lord. We are only concentrating that date of formation of the stack during his tenure. My lord, come to page 57, my lord. Of
the
writ petition. Page 57, my lord, third column, stack number, commodity and DOF, that is date of formation. It is 29/7/2017 during his tenure, my lord.
This is of which shed?
This is of set number 3, my lord, if I am not wrong. So during his tenure, we have made an assessment, stake-wise, data-wise, that in the last column, that is quintal, it is in quintal, as loss, that is 8.0 so and so, and as loss in percent, my lord.
So his loss is around 0.49.
That is 8 quintal of total.
8 quintal.
8 quintal.
Okay, this is of shed 3. But
Shed
here the loss is shown as 568.
My lord, I am coming, then again on the third number, third serial number. Again, another stack is there, 29/7/2017.
What about this 29/6/2017?
That is not in during his tenure, my lord.
Okay, 29/7.
29/7 during his tenure, my lord, date of
2482.
Then fourth one is 6/8/2017. Then again fifth is not during his tenure, sixth is there, 6/8/2017.
Hmm.
Then again, on next page, number 7, serial number 7, 6/8/2017. Here the storage loss is 3 quintal, my lord. In this manner, my lord, the
No,
total.
no, in this manner, if you go on also, show me that it comes to 568. Does it work out to 568, Mr. Gupta?
This, this 568, that is, in page number 54. Page number 54, this entire calculation is given.
Okay.
That 568.3346 that is there. This is for the entire, entire stock when it was liquidated. This is the chart which gives the.
Okay.
This is-
Okay.
This is a chart.
Yes, Mr.
Yes,
Singh.
yes, I'm coming to this.
Then,
Then out of his 568,
Hmm.
here in this chart, it has not been segregated that what was the total loss during his, but in Ankit Singh case, we are having that one.
okay, fine, let's be here. Now that 568 is there,
568.
you have come to a loss, unjustified stock loss. SL is stock loss?
Yes, ma'am.
Providing for.
Actual loss in
this-
quantity, that is.
providing-
But
Quintal,
SL, what does SL mean? Stock loss.
what is-
SL, S/L. What does that mean, Mr.?
Scientific loss.
Huh?
Scientific loss.
Scientific loss is 353. What is the loss
353, yes.
accounted to him?
353 point.
Oh, yes, my lord. I'm
It was accounted to him. But that is the thing after working out for all.
For a entire, yes. All his predecessors and all this thing.
Yeah,
The point is this, Lordship, there, it is clearly mentioned, by this, even this managing directors, the executive directors, AKK Meena says, in fact, Sri Ranjit Singh joined the set number 1 after departure of Gopal Das. It seems doesn't seem much culpability on the part of the petitioner in respect of the losses recorded during zero PB in said number 3. In the order he is writing that there is no culpability on his part. And what the immediate boss, the divisional manager is writing, from the above questions raised the analysis, it can be further claimed that the higher officials are involved in the entire opening and the said in charges were only made scapegoats. Then
we go.
one transaction report how one of the officials, Mr. Ranjit Singh, who had joined the depot only a few days back before the declaration of previous loss, can undertake such a fraud in only a few days of his joining. Even his superior bosses, they are acknowledging it. And ultimately, in the review petition, while deciding review petition, the managing director says that he has got no culpability in number 3, cell number 3.
My lord, I will also file a written argument, showing this stake-wise, my lord. In fact.
That is what I wanted.
Yes.
How long will we carry on with this?
Yes, my lord, that is very much difficult. In fact, Ankit Singh case, we have given a detailed chart, but they have failed to give in this, the first case, Ranjit Singh.
These people have been just brought in and you require somebody, fall guy, and they were the fall guys. That's all.
Your Lordship, they have been very sincerely working there.
Mr. Gupta, I'll not go into that. I'll not comment on that. I need not comment on that. I'm only required to look into whether that minor penalty proceeding initiated against you, leading to a recovery, is on the basis of some material, which I am finding it difficult to come to a conclusion to. That's all.
Yes.
Subject
just
to what
point out that one.
Mr. Singh will show me.
Yes.
One more last chance.
Yes, ma'am.
Tuesday.
Not possible. It's such a short time, my lord. On the next time.
Because what I
September
problem is
first
I'm
week.
not here from 19th.
Yes, my lord. That's I came to know.
So if you can.
September first week, my lord, I will produce. No.
Why? No.
This is big close.
I want to dictate this judgment on 15th and deliver it on 16th. That's all.
In such a short.
Why?
Because
Mr.
three
Gupta could
cases
do
are
it
there,
in 2
madam.
minutes.
Three
Mr.
cases are
Gupta
there.
could do it Mr. Gupta, give him a copy.
When your lordship is fixing 16.
No, I'm fixing it on 14th.
14 in Ethan.
You send somebody.
16, my lord.
You send somebody.
My lord, 16.
No, 16, because I'll not be able to dictate.
On the-
14th, you give it to me, send somebody. 16th, I'll have the matters listed.
14, your lordship is not hearing.
No, not hearing. I'll just take
I will
the
have to
matters.
submit.
Submit 16. I'm hearing concluded.
Hearing
You
concluded.
just give me your data, that's all. Heard, hearing, heard the Learned Council for the parties at length. Hearing concluded. Mr. B.K. Singh, Learned Council, Mr. G.K. Gupta, Learned Council for the petitioner, has submitted a written note with regard to the submissions made by him. Full stop. Mr. B.K. Singh, Learned Standing Council, FCI, submits that he would submit his note in the matter on or before 14/8/2024 to the court master. Registry to list this matter again on 16/8/2024 for delivery of orders.
Obliged.
Thank you.